Let's come back from the break, please. All righty, when we broke for lunch, we're back after a lunch break. When we broke for lunch, Mr. Tremaine was about to ask his questions of Mr. Purvis. Go ahead, Mr. Tremaine.
Thank you, Madam Hearing Officer. I'm just getting booted back up into, I wanted to screen share, so. Okay. Good afternoon, Mr. Purvis.
Good afternoon.
Thank you for being here. I hope you had a good lunch. I'd like to, if I can, please share, I'd like to screen share. Well, doing a very poor job of it. Oh,
Good
man.
drawing.
Yeah. That's, yeah. So while I'm floundering at this, this is amazing because I've done this in any number of hearings and this is not how it goes. Well, let's try this another way while I reboot here. So Mr. Purvis, do you recall your exhibit 52 discussing the breakdown of operators and wells and production that would be impacted by the cutoff disqualifying operators from blanket bonding?
Yes, I do.
Okay. And the current proposed rule, do you agree that it disqualifies operators from blanket bonds if more than 15% of their wells included in their portfolio fit the proposed definition of marginal wells?
As I told Mr. Rankin, I'm not sure I understand the interaction between the blanket bond rules and the buy well rules.
Thank you. I didn't mean to belabor that point. But the cutoff proposed in the rule
Is
is 15%, right?
Yes.
Okay. And would you agree that that 15% cutoff came out of discussions that the petitioner had with OCD and in response to edits proposed by OCD in response to the original petition?
I have no knowledge of where it came from.
Okay. To your knowledge, did WELC or any other party solicit feedback on this part of the rule from industry?
I have no independent knowledge.
Okay. Are you aware of any feedback or counter proposals or red lines related to this subsection for marginal well portfolios that have been provided by industry?
What I know about the origins of the proposal is just what's been covered in the hearing the last couple of days.
Thank you.
For that part.
Okay. So do I understand your testimony to generally stand for the proposition that setting that threshold for marginal well portfolios at 15% represents a logical breakpoint?
Yes.
Okay. Included, and this is why I was trying to share the slide, apologies. But on your slide 52, you listed several other breakpoints with breakdowns.
Yes, I did.
Including, I believe, 25%, 30%, et cetera.
Yes, that's correct. I did.
Do you believe after performing your analysis that those other thresholds for marginal well portfolios would constitute other also logical breakpoints that could be included in this rule?
Yes. Not all the points. The higher you go, I believe the less reasonable it becomes. But I do believe that something between 15 and 25% would be a reasonable number based on my experience and knowledge of operations in the industry.
Okay. Do you have any views on the breakpoint at 30%? Would that be a logical breakpoint, or do you draw the line at 25?
There is not as much evidence to suggest the 30%. And I think that in my qualitative experience, it's a high number.
Okay, thank you. Earlier today, Mr. Purvis, you shared applicant's exhibit number 86, variance of actual to estimated versus time for recently plugged orphan wells. Do you recall that exhibit?
Yes, sir.
Okay. And I think as part of that discussion, there was some questions and answers regarding $150,000 representing a reasonable average for wellbore plugging costs across the industry. Is that fair?
Would you ask again?
Yeah, so based on your analysis that's represented in exhibit number 86, would you agree that $150,000 as kind of like a placeholder for the average plugging cost, like that's a reasonable estimate of average plugging costs for wellbore plugging across the industry in New Mexico?
It's a reasonable estimate of the average across New Mexico, but 86 doesn't support that directly.
Okay. How would you clarify in response to my question?
Exhibit 86 pertains to the nature of the overruns. Not so much the qualitative average, but as I've said other times, we have a sample of several hundred wells of actual experience from the OCD's experience, and that is broadly representative and easily by far the most representative data available.
Okay. So do I understand the clarification then to be that you agree with my statement that the 150,000 is a reasonable average, but I shouldn't have attributed that to slide 86.
Correct.
Okay, thank you. When you break down and perform this analysis and looking at specific operators like you have broken out in slide 86, is $150,000 as a rough average for wellbore plugging costs representative of an average for individual operators? Do you understand the question?
I'm not sure I do. Please ask again.
Okay, so you have slide 86 broken down with the overruns plotted, and they're broken up by operator. And I was reading this along with the other testimony to say that 150,000 is a good average across all of these wells plugged, but they were plugged. The wells were registered to various different operators. So I want to say on a more granular level, can you make that same finding or determination if you look at wells that were registered and operated by specific operators?
I think I understand your question. We do have data on costs and cost overruns from a number of different operators. I have not specifically examined that data for variations, whether some operators are systematically higher or others systematically lower. But I also have not observed any sort of trend on 86 or other places that would suggest that some operators would be systematically higher or lower. That said, one caveat in my direct testimony, I said that there will be some variations from place to place, and I noted in particular the Raton Basin might be significantly cheaper, and an operator that's only in the Raton Basin would be some for those 700-ish wells. It would be different.
Thank you for that, Mr. Purvis. Earlier today, Mr. Cloutier asked you some questions about your reliance on the master orphan spreadsheet. Do you recall those questions?
I do.
Do you recall a question about 75% of wells on the Moss are clustered within 10 operators?
I remember some numbers like that. Yes.
Okay. Is it consistent with your understanding that as a predicate to inclusion on the Moss, OCD must have pursued and resolved a specific enforcement action?
Yes.
Does it follow that all wells on the Moss would be associated with the limited number of operators for which OCD has brought an enforcement action against?
Yes, that's necessarily the case.
Okay. Would you be surprised to hear that there are currently over 100 operators with registered wells in New Mexico that have not reported any production in the last 12 months?
I believe I testified to that fact. No, it would not surprise me at all.
I'm going to apologize in advance because we've done some having witnesses, please fact check lawyer math, and I'm going to ask you some more questions about that here. Do you recall questions earlier about the potential for loss of tax revenue in the order of $55 million?
Yes.
Okay. Following up on that, I believe you had found in your analysis that, and from the information available through OCD, that there's approximately 63,000 wells currently in New Mexico.
That's correct.
Okay.
And
And
unplugged wells.
sorry.
Unplugged wells are a total of about 100, over 110,000.
Okay. Thank you. I'm speaking about unplugged wells. So 63,000, roughly 63,000 unplugged wells. And we've heard a lot of testimony or presentation about industry plugging approximately 95% of wells over time and historically and on the national average. Do you recall that?
I do recall that.
Okay. And it's consistent with your findings that on a national basis, approximately 5% of wells are orphaned and have been plugged by orphan well plugging programs.
Correct.
Okay. Would you agree that 5% of 63,000 wells is approximately 3,150 wells?
Yes,
That sounds about right.
that's about right.
All right. And so if we assume that the previous trends of about 5% orphan plugging rate applies to wells, currently unplugged wells in New Mexico, it would be logical to conclude that a little over 3,000 wells will be plugged as orphans in New Mexico.
That's the math under those assumptions.
Okay. And we previously discussed average plugging costs, and I think we got to a point where we agree that 150,000 is representative of those average wellbore plugging costs. If we agree to assume that we're not incorporating other like surface reclamation, environmental remediation in that, we're starting with that number. Sorry, strike that. That number being based on wellbore plugging costs, if you were to factor in any other additional surface reclamation, environmental remediation, would you agree that $150,000 as an assumed average plugging cost is conservative, a conservative estimate of plugging costs, factoring in all the other costs associated?
I would characterize it a little differently.
Okay.
It would be it is much less than average decommissioning cost for full scope of decommissioning. Right. So the testimony from OCD was most recently in their experience that a surface reclamation and remediation with no difficulties runs $30,000 to $50,000. But the average was $225,000 of memory serves, and the high side was in the millions. Plus, of course, their time and effort to do the work.
So 150 is a reasonable average for wellbore plugging costs, but it is very conservative if it were to be attached to decommissioning costs.
Correct.
Thank you. We talked about there being over 3,000 wells that, based on these assumptions that I've laid out, that are likely to be plugged as orphans in New Mexico. Would you agree that number is consistent with or approximates the numbers in the LFC report?
As I recall the LFC report, I can double check that if you like.
That's fine. I can move on. Let's just assume that number I came up with 3,150. If we assume, as we discussed, wellbore plugging costs of approximately 150,000, my lawyer math comes out to $472.5 million. Does that check for you?
Yes, I did that math,
Okay.
anticipating that a minute ago.
Okay.
472 million.
Okay. Do you have any knowledge of how much money is appropriated for OCD to use on an annual basis for plugging and abandonment through the reclamation fund?
I do not recall.
If you assumed that would be going forward approximately $16 million, would you agree that based on these assumptions we've outlined, plugging the orphan wells expected to be plugged under state plugging program would take more than 29 years.
Yes. Also assuming nothing else is orphaned besides what is line of sight right now.
Thank you. Do you recall a question earlier where Mr. Rankin was asking you about the value of the lost oil production if we lost that 2 point something percent of production?
Yes.
Okay. That total worth. The total oil production on that slide, I believe, represented about 740 million barrels from that fiscal year. Is that consistent with your understanding?
That's my recollection, yes.
And using those same assumptions of $60 per barrel, the total value of that oil production, would you agree, is approximately $44 billion?
Yes.
Okay. One moment. Nothing further from Mr. Purvis. Thank you.
Thank you. Ms. Fox, do you have any redirect? I'm sorry, Mr. Nikhil.
Yeah.
Very sorry.
No worries. Just briefly. Mr. Purvis, Mr. Rankin had some questions for you about the financial impact of the proposed rules. I had a couple questions for you to clarify. Have any industry party experts quantified the financial impact of the rules on operators?
No.
And have any industry party experts quantified the financial impact of the rules on production?
No.
And have any industry party experts quantified the financial impact of the rules on state revenue?
No.
What information would you need of individual operators' financial records to determine the effect of the proposed rules on operator level economics?
If one were going to try to determine operator level economics, you'd have to understand the nature of the whole corporate entity. Some of the information about the companies is publicly available, their historical production, royalty interest, price differentials and such can be had from public data. However, the other information that would be necessary would be things like how much debt they already have, what assets and obligations they have in other states. The information that would be necessary to make a by company analysis is the kind of information suggested as possible information in the transfer provision.
Okay, and in your experience, are individual non-public operators typically forthcoming with this sort of financial information?
No.
Finally, you began to respond to Mr. Rankin about your projection of the change to recovery based on the proposed rules. Did you have anything to add or clarify on that?
Thank you for asking. I would like to just unpack that answer. Dr. Arscott's Exhibit 9 presents a range of possible effects of the increased cost of the bonding premiums on operating costs, but it covers an almost irrelevant range of the scenarios. So he's very clear that Exhibit 9 pertains to only 61 companies, those 61 companies that have only one well each. So the table as a whole pertains to 61 wells out of 63,000. Second, the rows in the table range from a 1% premium to a 10% premium. The 10% appears to come from the Ramey study, the least reliable of the sources. The consensus on the value concentrate around 2 to 3%. So to be on the high side, the conservative side of a central estimate, the relevant line is that third to bottom line. Now, in that situation, he applies the cost of $275 per month to base pre-existing operating costs of $1,500, $2,500, and $5,000. Earlier in his testimony, he explains that flowing conventional gas wells, presumably dry, range from $1,200 to $2,000 per well per month. That is going to be a very small number of wells. Probably applies to the Raton Basin, although the Raton may also include the dry gas presumably dry gas with a compressor, which ranges up to $4,000. Coal bed methane, he says, ranges from 3,500 to 5,000. So now we're beginning to get into the range of operating costs that are common in the state. But he draws no opinion about the operating cost of wet gas wells. But for oil, he states only a high side of 14,800. By comparison of the high side to the low side, then the number should be around $10,000, which means a median estimate by Dr. Arscott's work of the monthly operating costs for an oil well, vertical oil well in the state of New Mexico is on the order of $12,000 per well per month, to which, if you only operate one well, you add $275,000. So the 6%, as shown in the table, applies to a modest set of the wells. But if you increase the operating cost to reflect the 71% of the wells in the Permian as a proxy for oil wells, well, then that same $275 becomes 2.3%. But remember, this is still for a company that has only one well. His other related table close by, Exhibit 9, shows the range of incremental per well costs that different companies suffer. And most of them are not $110,000. Most of them are on the order of $50,000, $39,000 to $53,000 or so thousand. So if the bond is incremental cost is for $50,000 instead of $110,000, then the incremental cost to the average oil well is 1% operating costs. And that means that if a well is declining at a 12% decline rate, it will decline 1% more or less per month. So the incremental cost for most operators on most wells is on the order of 1 to 2, maybe 3% in 3 months of production, of the lowest rate of production ever in the history of the life of a well. That, according to the standard theoretical model we use, setting aside its accuracy and setting aside the additional motivation to keep wells on beyond the economic limit, the direct effect on economic limit is trivial.
Thank you. We have no further questions. He's available for questions from the commission.
Thank you, Mr. Ankiel. Commissioner Ampoma, do you have questions of Mr. Purvis?
Yes, I do. I do have quite a number of questions for you. Thank you for your testimony. So I'm looking at your PowerPoint presentation, and I do have from page 1 to page 59. So I just want to make sure that we are all talking about the same document. So I'll start with page number 5. That would be the exhibit 39. Historical cost of downhole plugging for orphan wells in New Mexico.
Yes, sir.
So my first question for you is that, based on all these proceedings and then the testimony from NIMOGA, IPNM, do you have a fair idea as to how much the industry is saying it will cost to plug a well in our state?
There's very little, I found very little information, Commissioner, in the testimony about what it would cost on average. My rebuttal testimony summarizes all the incremental information that I have from industry in this setting about costs.
Yeah, and sorry about that. I did not see your actual, I was focusing more on the PowerPoint, and later I got to know that you've really detailed your responses. So some of my questions might be that I have not really spent a lot of effort on that. So just forgive me on that.
No problem.
Okay, appreciate that. Now, my question to you, again, still on that same exhibit 39, is there any correlation with depth with regards to these estimates?
I have not examined the relationship of the cost with depth. We know from the literature that there is some relationship, and from first principles, but it's a weak relationship.
When you say it's a weak relationship, so let's focus on San Juan Basin, for instance. Are you familiar with the formations that oil, let's say gas is being produced from?
Pictured Cliffs, Mesa Verde, Fruitland Coal. I am.
So Fruitland Coal is about the depth, do you know?
It varies. If memory serves, it's on the order of 5,000 to 7,000 feet deep.
Fruitland Coal?
Please correct me.
No way. I mean,
I'm sorry. The last time I worked
Okay.
with Fruitland Coal was
So-
1992. I
okay,
apologize.
so
for my
let's say
memory.
that the Fruitland Coal is much shallower.
Okay.
You know, I remember when we drilled our well, probably 1,500, 2,000 thereabout. And then Dakota, that one is much deeper, which is about 7,000 thereabout.
Mhm.
So is it your testimony to the commission that the cost to, let's say, plug a well in Fruitland Coal is going to be more or less average cost the same as more or less 8,000 feet, Dakota?
No, there is a correlation. The greater depths require more plugs in general, and it requires longer trip time to set the plugs. There is a correlation, but the other drivers, there are many other drivers of the cost, and so it's not a strong correlation.
Okay, then I get your point. We'll dig deeper into that question when we get into the actual proposed rule. So still on Exhibit 39, so is it your testimony that the applicant more or less used this analysis to set the 150,000 bond per orphan well or per marginal well?
The 150,000 was set before I created this exhibit, but I believe they did rely on the same original source material that I relied on.
So then can you tell the commission where the source of the 150,000, where it came from?
Yeah, it's in the my work cites the reports of the OCD, the annual reports of IMNRD, and the presentations given by OCD to the legislature. And some of the lesser data has to do with OCD reports to the IOGCC.
You touched on the fact that the depth is a weak correlation. So what other parameter really contributes to the cost of the plugin?
The nature of the fluids that have been produced, the age of the well, the construction of the well, which is strongly correlated to the company that drilled the well, the nature of the formations behind pipe above the producing formation below the surface, and the nature of the access can be an issue. Access to the site.
Let's go to slide number 6. Exhibit 33. History of daily production in New Mexico in 6 categories for major divisions among basins and types of wells shown on 4 vertical scales.
Yes, sir.
Okay, so
I apologize. Could you, just so that I can follow along with your questions, exhibit 30,
no, 33?
okay,
Yeah. Right there, yeah.
got it. Okay, thank you.
Okay, thank you. No problem. Okay. So you do have Permian on the left and then San Juan on the right, just to confirm that.
On the right side includes both San Juan and Permian.
Okay.
Actually, all 6 graphs, all 6 groups are on all 6 graphs. But on the upper right corner, the focus is on the vertical wells in the San Juan Basin and the vertical wells in the Permian Basin. If you'd like, I can share my screen and zoom in.
No, I can see it here. I appreciate that clarification on that. Thank you. So my first question to you is that looking at, let's say, these production profiles, did you do any analysis to see if, let's say, the impact on these production profiles that we're seeing here, if these rules were enacted 10 years ago?
No, sir, I have not.
Now, would these proposed rules, new rules, based on your analysis, increase or decrease oil production in the state?
There are competing dynamics, and I have not quantified those.
When you say there are competing dynamics, can you expand on that?
On the one hand, it does create an incremental operating cost. On the other hand, it also creates an incentive to keep wells operating below their economic limit. So on the one hand, there may be more production, and on the other hand, there may be less. The volume that is affected is de minimis, and so the effects one way or the other will be small.
Now, another question for you still on this. Did you compare the production contribution from major operators and also from small operators?
Yes, I did, to the extent that I show on exhibits 37, and if memory serves, no, not memory. 79, the relative contributions by rank size. Applicants Exhibit 79 also shows the relative contributions historically by absolute size of companies.
Yeah, so can you just help me understand what to be what was the contribution from the small companies?
Over the last 30 years, the bottom 90% of companies by cumulative production have contributed 3.5% of cumulative production in the state. That number is less in 2024, when the bottom 90% of companies contributed 2.5%.
Okay.
Companies is really not a relevant measure of significance.
Well, when you say company, it's not a significant measure of relevance. Well, don't you believe that, let's say, if the commission enact this rule, the small companies are really the ones going to suffer?
The small companies do preferentially own the kinds of wells and the kinds of portfolios that are affected by the rules. They're not the ones, I would say, who suffer. I would say they're the ones who are being held accountable. If, to the extent that a company has made adequate provision to meet their legal liability that's longstanding, well-known, then it would not create suffering.
Okay, we will dive deeper into that. Let's go to slide number 10, Exhibit 38. Schematic of cash flow for hypothetical oil and gas project to demonstrate the economic concepts of payout and hold back. And, one thing that I really want to clarify, so there was a back and forth about the SPE paper.
Yes.
I want to clarify this, that are you aware that after the abstract has been reviewed and then we put in the full paper, there is an actual review by the committee before they allow you to come and present? Are you aware of that?
Yes, I have served on that committee, and that is true.
Okay.
It is rare for a paper to be rejected. It is also rare, but I have seen instances where a paper was forcibly withdrawn for its quality.
And I do know that, they provide extensive feedback, and you need to respond to those feedback.
That's true. I've served on the committee a number of times, and I have provided robust feedback.
Okay, let's get back to your slide number 10. So is it that the applicant is actually advocating for single well bond and not necessarily the blanket bond requirement?
I'm not sure I understand the question. Certainly, the largest part of the proposal pertains to single well bonding. So,
the reason why I'm asking that is that, for active wells, you still put a 250,000 blanket.
Yes, sir.
But for, let's say, the marginal wells, you are going one after, let's say, each well. So I'm just asking that, is it the applicant main objective here is to more or less do away with the blanket bonding and then just focus more on single well bonding, especially for the marginal wells?
I'm not sure I want to opine on what the intent of the focus and motivation is in that way, but I will say that with the rules as written have a much larger impact. The by well provisions are much more significant than the blanket provisions. Does that answer your question?
Yeah, there was a slide that I think will be much helpful, for us to go through that. So I'm not going to push much on that one. Yeah, but on that one, just on what we're just discussing, why is the applicant not advocating for the correct bond right from the onset?
I do not know. I have studied this issue in other places and recommended that a full cost bond from the point of drilling is a natural and reasonable solution.
So if, let's say, the applicant went for that, don't you believe that small operators will not necessarily say you are coming after us?
Yes, that would follow.
But why is the applicant not pushing for that though? Do you know?
I do not know. As I said before, I was not involved in the original creation or most of the terms.
Okay.
I will say one other thing, though, Commissioner. That provision would not affect the 63,000 existing wells. There are hundreds of wells being drilled each year. And if a full cost bond was placed in escrow and then could transfer from operator to operator, not full cost bond, but a full cost provision and could transfer to operator, it would only apply to the wells newly drilled each year.
Exactly. So 10 years from now, I mean, we would have solved that issue right from the onset, right?
Well, it would have solved the issue for the wells that continue to be drilled, but we drill on the order of hundreds, I believe, maybe 1,000 wells a year in New Mexico. But there are 63,000 for which there is not the opportunity to get the same money at completion. There's already this backlog.
Yeah, it's backlog. So what you are proposing now more or less solves the backlog, right? What the applicant is proposing now will more or less solve the backlog.
It is an attempt to solve the backlog.
Yeah, but still, I'm trying to make a distinction here with regards to why are we pushing this on the smaller operators, whilst the big guns who can pay this don't pay it right up front.
I would personally support a full cost savings fund, an escrow fund for a well at the point of completion. And I wrote a paper published earlier this year that dealt with the issue of impecunious wells in northern Appalachia and proposed a solution there, which you can read about later. But that is beyond scope of what we have to deal with today.
Yeah, let's go to slide number 11. Now the 180 days and less than 1,000 BO within consecutive 12 months determined once per year. I believe this is OCD's definition, or is the applicant's definition?
It's the definition of the proposal. I don't recall its origin. I believe that did. I seem to recall it came originally from the OCD.
Okay. Is this acceptable by the industry?
I do not know.
As I research on it, it sounds to me that even probably OCD is a little bit generous compared to EPA. Is that a fair statement?
I do believe that the definition of marginal wells is quite generous. If I could point you to Exhibit 40. Here we go. I don't believe I'm on the share anymore. This is the cross plot of the two criteria for wells as they produced in 2024. And the black dots are all wells. Each dot is a well. And the ones shown in black are ones that are not captured by the current definition of marginal. So what we see is that there are a large number of wells that produce very small volumes, but are reportedly active for more than 180 days, and they do not qualify as marginal. In my direct testimony, I point out a particular well on the far right on the side that produced for 365 days and produced 3 barrels of oil reportedly, and does not qualify as marginal or no beneficial use.
So is it your testimony that the applicant really did a lot of due diligence to make sure that they minimize the impact on the industry?
I can't speak to their due diligence. I can say that it does look to me like it minimizes the impact. It's quite a conservative definition for financial risk.
Let's go to slide number 12. Proposed systems of financial assurance and safeguards. I want to understand a little bit more. Let's say under the active wells, section 1 or number 1. So the ones that has already been crossed out. Do you know how that rule was developed? What was the thoughts behind the existing rule that we're trying to correct? Do you know?
I do not know the thoughts behind the existing rule. I will note that if you did like the existing rule, you could set a base cost of $135,000 a well and $2 per foot, or $140,000 or $145,000 and $2 per foot, and get to about the same point.
So don't you believe that, the original intent of the rule also took into consideration the depth disparities in the plugging of the well?
I do not know about the intent, but the wording absolutely does take into effect that that variable, which we know does have some effect on cost.
So why did the applicant not actually try to, because I'm a little bit concerned about, let's say, a full on coal 1,500 feet, you don't need to put the same bond compared to 10,000 feet. Well, I mean, and if you look at the small producers, more or less take the shallower zones formation. So I'm a little bit concerned about putting this blanket bond, which definitely is going to, the small producers are the ones really going to suffer. So why did the applicant not necessarily look at the original description and then try to at least work through it to more or less cover, the small producers?
The intent and reasoning I can't speak to. The effect I can tell you is simplicity. In one of the papers in particular that I cited, the author concluded that efforts by the regulatory agency to fine-tune the bonding costs were likely a loss of social benefit. And that paper, by the way, did not consider whatever the statute may be in New Mexico. But I'm saying that the advantage of it as it's written is simplicity.
So is there any state with major oil production? I mean, New Mexico, we are probably number 2, Texas number 1, North Dakota. So is there any other state with major oil production that do have this 150,000 more or less financial assurance that you know?
The state of Colorado adopted a really complex set of rules, the baseline of which, and that was adopted in 2001 or 2, and the baseline cost assurance was $130,000 per well.
Do you know if the applicant more or less did a survey of virtual producers, and also helping to come up with the 150,000? I do know you've talked about Vectex. Was that the one, or do you know if other survey was done?
I do not know what other experts did or did not do, Commissioner, but I can tell you that I looked in every way I could. The Vertex report was one that I found. I also tried to extract from annual reports of oil companies operating in New Mexico an implied cost. I scoured the reports of operators in the direct testimony. But more importantly, I don't believe the cost to the operators is the relevant measure, because the financial assurance is meant to protect the state. So what the relevant measure is the harm to the state, or the potential harm to the state.
Yeah, potential harm to the state. But these wells already been drilled. There is a producers ongoing. So what you are coming in right in the middle is more or less going to put that out of business. And I don't know if, let's say, to the state, but have you also looked at these companies that are going to be affected, their contribution to the community, and then also to the state at large?
As I said before, what I have examined is the production and the wells that they operate, because those are direct indicators of the financial economic contributions.
So with regards to the 150,000, I think we can all agree that based on OCD's experience of plugging often wells, so, and then even the chart that you showed earlier on, we can agree on that. What about the number two, the blanket bond of the 250,000? How was that number? How did the applicant come up with that number?
As I understand, that number is constrained by statute.
So that number is taken from the D, which has been crossed out. Is that one like 250,000 for more than 100 wells?
The same number does appear in the previous version under D. I'm not sure I understand the question.
So I'm just asking, you said that one is based on statute.
Yes, as I
So
understand it.
you cannot go above that.
For blanket bonding, that's
For blanket bonding, you cannot go above that. And I'm just trying to look at it and say, does it have any relationship with D?
I imagine, I'm speculating that D was set for the same reason, but the origin, the statute is beyond my real expertise.
Okay. On slide number 13, proposed system of financial assurance and safeguards. So I'm looking at number 3. An operator with 15% or more of their wells in marginal or inactive well status or a combination thereof shall provide a well plug-in financial assurance in the amount of 150,000 for each well registered to the operator until the percentage of the operator marginal and inactive wells is decreased below 15%. So there was a back and forth with you and Mr. Shemaine. So he suggested 25%. Do you agree to that? Was that something that you agreed to?
What I said before, or tried to say, was that I think a number between 15 and 25% is a reasonable number. The higher it goes, the bigger stretch, the less reasonable it is. But I certainly would not go below 15%. What I can see empirically is that most companies, and what I know from experience anecdotally, is that 10% or less wells that are truly idle is pretty strict.
So let's go to slide number 14, the beneficial purposes. So we've talked a little bit more about the speculative purposes, and I saw that you're trying to link the speculative purposes to the PRMS. That is more or less acceptable to the Petroleum Engineering Society. I still could not get the linkage between that.
So the Petroleum Resource Management System is designed for application to oil and gas volumes that will be produced in the future. And what we're talking about here is a broader scope of uses beyond just production. But the set of thoughts that they created about the criteria and the taxonomy for a project in general is transferable. So you could take the definitions, either the issues that they conceived of or the definitions directly, and apply those to geothermal or gravity energy storage. For example, in the construction of the PRMS, they decided that a project needs to be justified both technically and financially. There must be an intent and there must be the ability to execute. When you have those, then you have a project. And as a project is being developed, you may have one or not the other, and one issue may be met and then lost. But if you use that construct to think about speculative use, you could define a criteria. It is, in my opinion, definitely speculative if it has no technical justification, no economic justification, no intent, and no feasibility. So there's a gray area. If you have all of them, you clearly have beneficial use. If you have none of them, I think is clearly speculative. My proposal was that you could consider those criteria in defining more clearly a line.
Okay. Then why did the applicant not use that to more or less define the speculative purposes, for the benefit of the commission?
I first brought that idea after we submitted direct testimony. I didn't have a problem when I read the original proposal with the idea of speculative because I was satisfied that the term is clear enough. But then with further discussion, I was able to offer the idea.
Okay. On slide number 15, so there was a discussion about this with Mr. Alexander, and I want to get your thoughts on that. So under D, number 1, documentation demonstrating that the well is reasonably projected to produce in paying quantities. So, I mean, how do we quantify this, especially if we are dealing with, like, let's say, an injection well?
So the economics of of a commercial injection well are a little different, but there's still a matter of what they get paid and what expenses they incur. If you're talking about an injection well that's owned by the operator who's using it to dispose of his own waste, there is a straightforward way to handle this. It's a group economics. We often do analysis of economic limit on an individual well-by-well basis, and that simplification works in a large majority of cases. But it's not complex. The most common software for this kind of analysis in the industry does perform group economics.
And then there was a definition somewhere too in the rule that specifically targets the SWDs, where they cannot, if they are not injecting like 100 barrels or something like that. Do you recall that?
Vaguely.
Okay. So would that more or less cover the SWD side? And this provision specifically is for production well. Is that your understanding too?
I don't know how the two interact. I could look at it some more and give you an answer, but I haven't considered how those two interact.
So yesterday I had a back and forth discussion with Mr. Alexander about the exceptions that needs to be made, going through the, let's say, continuous production cycle in a typical field. He agreed to some exceptions. I don't know if you recall that discussion.
I think I recall talking about extending temporary abandonment beyond 8 years, beyond the 5-year extension and then the 2-year extension.
So then let's go to slide number 16, and let's discuss that in more detail. So that will be 19.15.8.9.e.
Yes.
Inactive wells and wells in approved and expired temporary abandoned status. So which of these categories will the exception, if you agree to the exception, which of these categories of wells would these exception fall under?
So it's not my proposal and not my job to make a compromise. I will say that I understood the exception to apply to wells in temporary abandonment status, not wells that are inactive in contravention of the law.
So when I look at, let's say, this provision E, and then I try to put in the exception, it doesn't seem to line up. So the reason why I'm saying that is that is a well that we agree that needs to be exempted from, let's say, this provision, would that well still needs to put up like $150,000 per well bond?
Are you asking my opinion on what it should be?
Yeah, I'm asking your opinion.
Yes. If you're going to leave a well unplugged for more than 8 years, that's extraordinary. And it certainly should have financial assurance because The longer it sits there, the lower probability it will be used and the higher probability of a cost overruns for its plugging. If you want to keep the option open, then it only makes sense to me that there's some security associated with keeping that option.
Yeah, so that exception that we discussed, when you say that you're keeping a well, let's say a TA well for more than 8 years, it's extraordinary. Let's think about it from production. You know, let's say an operator would drill like 60 wells to go for production. A subset of that will go for secondary. Are you following me? Or more or less, some of the producers will be converted to injectors.
Historically, in a conventional field, some fields have been water flooded, and implementing water flood does convert some wells to injection.
Exactly. And then not all of them normally, you know, even they do it pattern based because they look at the performance and then they move to another line and they move to another line.
Sometimes that's true.
Exactly. So more or less planned.
Sure.
And even you add CO2 to it. So I would say that 8 years is probably not extraordinary as you are describing it, because you will see that some of these wells will have more usage into the future depending on the pattern sizes that the operators would like to operate.
I think I understand your concept. What I observe is a couple of things bear on that matter. First, it's better to implement a water flood earlier in life rather than later. And you wouldn't want, you're talking about an 8-year time frame that begins after the well has been dead 8 years. I'm about extending it after a well's been dead 8 years, which puts it deep into the life. Second, at a larger scale, I'd observe that there has been very little exploration and very little new fields and very few water floods, very few CO2 floods in recent decades. Now, shale reservoirs are a slightly different matter. But the last time I saw a CO2 flood possibility was 20 years ago, when Oxy hired my firm to investigate a possible water flood in the Delaware Basin. Now, what I do see as potential use in the future are genuine repurposing, not reusing from different kinds of production, but genuine repurposing. For example, the gravity energy storage is at a point in life where we understand the technology, but it's not proven to be commercial yet. It could be 8 years before low temperature generation or gravity energy storage is clearly understood, and its viability clearly decided. But that's where the ideas of the PRMS come in. If the project is in process, as your example, you're in the process of piloting and testing and moving through, then that's clearly a project that's in process, and it's at the high end of the contingent resources and much closer. But if it's something like gravity energy storage, where they have not yet proved an economically viable commercial model, that's on the low end. So I have more concern about the possible use of the wells for novel purposes that remain unproved than for CO2 and water flood.
Yeah, so definitely the wells that could benefit the state, you know, from more oil, primary, you know, let's say the secondary and then the tertiary. I don't know how you're going to describe that in terms of, let's say, your the provision under E. Is it inactive wells, or is it wells in approved TA or expired?
So I'll tell you what I understand, subject to the folks who understand the law better. My understanding, based on what I did review, is that a well that's inactive is in violation of the current existing statutes, is not allowed to exist in that status more than 15 months, or not allowed to stand without doing anything for 15 months. So if there shouldn't be anything in that category, everything that's being preserved should be preserved under existing statute as a temporary abandonment.
So then what we are discussing will probably be part of the wells in approved TA status.
What I was discussing about extensions?
Now I'm talking about, let's say, the wells that production wells, probably they are not producing a lot, beyond the primary. So they are produced, let's say the water cut is about 99. So operator will shut that one in more or less TA, that temporary, until they move to water flood. So that one will fall under the wells in approved abandonment
Yes,
status.
and especially in a water flood where there's increased mechanical risk, it would be appropriate to put it in TA status, and it would be appropriate to provide financial security, in my opinion.
Exactly. So that financial security, if you look at this provision that we have here, it sounds like they will also be subjected to the 15,000 per well. Why not the blanket 250,000?
I'm sorry, I can't answer that. I do not know the interaction between the TA status and the blanket bonds for active status.
Yeah, because like let's say you have wells in approved TA status, meaning they've been able to prove to OCD that they do have beneficial use.
You're asking a hypothetical.
Yeah.
Okay.
Well, not necessarily, because Mr. Alexander agreed with the commission that at least there has to be some exceptions, right? And if there has to be some exceptions and we do not have any full description, we do have for active wells where you have the blanket to be 250,000 bond. But I feel like this one has to go more or less for the folks that are not really compliant, in terms of the E provision. Because you do have approved wells in approved status, why should there be a bonding for these wells, 150 each one?
So I'll tell you what I think you're asking.
Okay.
I think what you're saying is if the well is secured in a temporary abandonment status, why does it require an incremental single well bond rather than why would it? What's conceptually? Okay. A well that is in TA status has expended a significant portion of the funds that would need to be required for permanent plugging. They've pulled the string out of the well, set a temporary plug, as I understand the rules, and removed from the site all of the equipment. So it is a significant expense. On the other hand, its future use is of varying certainty. It's not a PDP. It's not approved, developed, producing well with cash flow. It's a well about which we have belief that we will eventually make money. And given the lack of confidence, I do believe it is appropriate to have initial financial security specifically for that well, separate from the de minimis $250,000 blanket bond.
Yeah, I mean, that one, don't you believe that we are going to force operators to really plug these wells prematurely? Because think about how much oil we've been able to recover from enhanced oil recovery projects. So let's say assuming all these wells, because of the 150,000 bond, they decide to plug it. I mean, think about how much oil that we're going to lose, especially from the Permian. I mean, how much oil are we going to really lose if these companies are to rush and then plug the well? Because it becomes cheaper to plug the well than to probably go after that oil in the future.
I don't believe that's the case, Commissioner. When the new provisions provide new breakpoints where additional financial assurance is required. And to be clear, the rules require a third-party guarantee. The rules do not require $150,000 collateral. The $150,000 collateral is a judgment made by an independent third party about the financial risk of the operator. What the rule does require is a premium on a bond. That does increase the cost of maintaining the well. But the alternative is always still plugging. In almost all cases, the full scope of decommissioning will be less than the cost of bonding, even with collateral. Bear in mind that for example, if my well is losing money and I'm paying $4,000 a year for a bond to keep it active, The alternative is hundreds of thousands of dollars for plugging, for full scope of decommissioning. The 4,000 is an easy choice. If I expand that analysis and consider a $4,000 annuity in perpetuity at a 10% discount rate, the present value is $40,000. It is by far more economical for a company to keep a single well bonded at $4,000 a year than it is to pay for the decommissioning.
You know, you brought up a good important point where, let's say, this 150,000 is not actually cash that is in the bank, you know, that operators to say, no, this is my capital. But is that not increasing the cost to get a surety bond? And even some of these wells or companies will get to a point where these companies are saying, no, I cannot insure you because it's so high. The risk is so high.
So the way that the bonding, there are other experts on the bonding market.
Okay.
In my experience in the bonding market, they're going to, and what I've read from the testimony, is that all right if I speak to that? Is that they charge a premium, and then when the risk is high, a collateral. So if the bonding company is providing a guarantee of $150,000, they can ask for and require up to $150,000. In which case they suffer no risk. They collect the premiums, but they have in the bank someone's earning interest. They have in the bank all the money necessary to fulfill the obligation. So the question of the difficulty on an operator is primarily the question of how much collateral the third party will require of them. To the extent that this party looks at their finances and their assets and the whole company and decides that they're a bad risk, they will require more capital.
So on the two, a blanket plug-in financial assurance equal to an average of 150,000 per well. Is this really a blanket financial assurance? Is it really a blanket financial assurance?
I'm sorry, I don't understand the question.
So the number two, a blanket plug-in, I'm still on slide number 16. A blanket plug-in financial assurance equal to an average of 150,000 per well, covering all of the wells of the operator. So I'm asking, is that really a blanket?
I would not use the word blanket to describe that, but I would defer to someone else if they told me that was an appropriate label to put on that kind of bond.
Yeah, so definitely you will not use blanket, but it is blanket right here. And when I look at it, it doesn't seem like a blanket to me. And it sounds like you agree to me. You agree with me.
I would not characterize it as a blanket, but I would defer to someone else who has deeper involvement in those policies.
So there's someone who can speak to what should be the right language there.
I believe there are people who can speak to the proper term for that kind of bond.
Don't you believe that this one is quite overstretched compared to the existing rule where they have A, B, C, and D, you know, specifying the number of wells here and there? Don't you believe that that 150,000 per well is really a stretch?
No, I believe I've said a number of times, I believe that the proposal as it stands is quite conservative. Perhaps this is the disconnect. It is a significant increase from what was before, but it remains a significant deficit to what is needed. My focus is on the comparison to what is needed.
So I think the whole objective here is to make sure that we are successfully plugging these wells that are not more or less classified as marginal and then become orphan. That is the main objective.
The main objective is to securely plug all wells by industry as opposed to by taxpayers.
Okay. So then, you know, Mr. Shemaine, when he was going back and forth with you discussing about how much money they can get from the reclamation fund to plug these wells, don't you believe that probably that should have been more or less the avenue, you know, to more or less make some recommendations to more or less improve that amount that OCD gets on a yearly basis?
As I said before, the best concept I have for a financial assurance regime is outlined in a paper I wrote earlier this year. What I like or would like to see or would recommend is not part of the proposal. I do think we all agree that industry should be paying for the cost and not the taxpayer.
Yeah, the reclamation fund, isn't all the industry paying for that?
The reclamation fund it does come from tax on the industry, and it does go to pay up the industry. The issue that I'm concerned about is the shortfall of the reclamation fund to deal with the line of sight orphans, and particularly the tens of thousands of wells that are already near the end of their economic life.
Yeah, let me try to wrap up here. Let's go to slide number 29, and that will be 19.15.8.9.g. So you are describing, amendments, or let's say changes to the financial assurance on a yearly basis, right? Don't you believe that industry needs certainty, in the process, for them to be able, because we also have to be competitive as a state, right?
No, I don't agree with that.
You don't agree with that?
As I described in my rebuttal, the literature on tax competition for mineral resources, the kinds of things that can't leave the state, is pretty uniform that tax competition is not effective.
Tax competition is not.
The concept of tax competition is one jurisdiction will lower their taxes so that they can compete for and preferentially get the business of companies rather than an alternative jurisdiction next door.
So you're saying that if Texas makes it much easier for operators to operate in their state, you will say that, it's not going to be in direct competition with New Mexico if we have certain really strict laws?
The literature shows that there is little loss of activity in the state with the higher costs.
Interesting. Thank you for your time. I appreciate you. Thank you.
Thank you, Commissioner Mpoma. Commissioner Bloom?
Thank you, Madam Hearing Officer. Welcome, State Representative Mark Murphy. Nice to see you here. And maybe I know Mr. Murphy had some comments that were provided as he's a witness for IPA&M, so maybe I'll start there. Mr. Purvis, you haven't talked about this today, but I did ask this question yesterday. One of IPA&M's witnesses' concerns or complaints was that once a well leaves marginal status and it has that bond because it was deemed marginal, and it has a single well bond, once it leaves marginal status, under the current rule is proposed that single well bond would need to be retained because it can't be canceled, apparently. Do you see any reason for that?
I don't see a reason for it. I also don't think that's what the proposal says. As I have understood the proposal. Thank you. I also don't.
You might want to start your answer over there. So.
Thank you. I see the reasoning for not maintaining a financial assurance on a well that's no longer qualifies under the criteria. But more importantly, as I understand the rules and how they're applied, the bond is only required on the wells that are currently marginal. A well that is no longer marginal, that has successfully improved its production, no longer has to post a single well bond.
Okay. Yeah, and I guess the concern was that bonds can not be canceled once they're issued. I guess the bonds that are taken out in New Mexico, according to that witness, said that they could not be canceled after being issued, and therefore would always be in place even once the well left marginal status.
Yeah, in my experience, operating a grand total of 3 wells, a bond is a contract for 1 year at a time.
Okay, thank you. I also noted that two or three of IPA&M's witnesses, many of whom own companies and are operators, said that they find substantially lower dollar figures for plugging and abandoning their own wells versus OCD's average cost. Might it be the case that orphan wells are more expensive to clean up because they were last run by companies that could not or did not want to care for them?
That certainly could be the case. It could also be the case that they're talking about data from 3 or 4 years ago that's not relevant.
And put another way, would it be fair to say that perhaps better companies that don't let their wells deteriorate, companies that clean up their spills, that always intended to P&A their wells, have ultimately lower P&A costs?
I think that's a fair theoretical idea. I don't know any way to test it quantitatively, but certainly a fair idea.
Yeah. So we might be dealing with two different sets of companies with different outcomes.
Yes.
Okay. I'd like to refer to the applicant's pre-hearing statement, page 739. Maybe you could pull that up. I have it up here. I can find it. This hasn't come up, I don't believe, in our discussions today, but Mr. Purvis, I believe you cite two studies, Boomhauer 2019 and Lang and Redlinger also in 2019.
I think the Lang and Redlinger is a different year, but I do cite both those papers.
Okay, yeah. And what these find, I'll quote, I'm looking at page 739 of the pre-hearing statement. Must have different pagination.
Page 52 of the of your direct.
You have 45 over there, huh, on your page.
I'm looking at a PDF. It's 955 pages.
And may I revise one statement I just made? You said that different costs for different companies. I might characterize it differently as different costs based on different paths to the point of being plugged.
Thank you.
Commissioner, just to clarify, the number of the PDF page doesn't align with the Bates stamped number. So just to distinguish where you're locating.
732 of the PDF or of the document. And the, yeah.
So for the record, the Bates number is 0732, is that correct? Right, and it says page, you're looking at the page that says 45, it's got two bullet points at the
Yes.
bottom.
Yes.
Yes. So the Bates number is 0732.
Yeah. So you quote from your paper, Mr. Purvis, and said that Boomhauer 2019 examined the effects of increased bonding in Texas in 2012, but especially in 2002, and Lang and Redlinger 2019 examined the effects in 2012 of increased bonding and other costs in North Dakota. Both studies support the conclusion that these policies have little effect on overall production. And why I'm interested in this is it gets to some of the waste questions that we're concerned with at the OCC. Please, any comments?
I would point out that both these papers found a change in production that were a fraction of a percent. I would observe that if the commission were concerned about a fraction of a percent, then it should revisit its rules on venting and flaring and waste gas, and it should revisit its rules on spacing of horizontal wells.
We just redid our rules on methane.
Just a suggestion.
Thank you. That was another few months of our lives. But thank you, Mr. Purvis.
Glad to help.
Not before Christmas, anyhow. Yes, I think you went on to say that Boomhauer observed that a small number of firms shut down after an increase in bonding requirements took effect, but most of their production was transferred to larger operators. Let's see what else. I think the last bullet on the page, the primary effect of the policy was to reallocate wells from small to larger producers. The bond requirement moved from about 4% of wells operated by the smallest 80% of firms to new operators. Another 1% of the wells operated by these firms were shut down, primarily representing low-producing wells where social cost is most likely to exceed social benefit. It goes on to say environmental outcomes improved sharply, as you just stated. And then we come down on page 733 to a synopsis of the Lang and Redlinger 2019 study. You write, Lang and Redlinger 2019 looked back at the 2 years of activity after the change compared to the prior 2 years in order to normalize for other factors. The authors compared activity around the state's border with Montana, which did not have a corresponding change. Thus, rigorously controlled for other variables, the authors conclude, quote, results find no statistical change in the pace of drilling wells after the North Dakota regulations came into effect, end quote. And then, quote, the reduction in production for small operators in North Dakota after the regulation went in effect relative to production in Montana is about 0.5%. The reduction in production from small operators seems to be coming from operator exit. You go on to say the authors found that 8% of operators exited, but still the effect on drilling and production was trivial at best. I think I'll leave that there. Any other comments?
I believe that you read all that correctly. I would only add one other thing. The article, the journal paper reproduces a quote from industry. The president of the North Dakota Petroleum Council stated about the rules that had those de minimis effects, quote, they are the most onerous regulatory changes we've ever seen. Now overly burdensome and among the most stringent and costly in the nation. And so I'd just point out the disconnect between the expectation, the representation of industry, and the quantitative effect by academics.
And these were, just to kind of recap, we were talking about changes to financial insurances in Texas and North Dakota where oil and gas is still doing well.
Yes, sir.
Okay. All right. Yeah, thank you. I just wanted to explore that concept of waste and that this potentially would not lead to waste given what we've seen in these studies and their looks at Texas and North Dakota. Finally, we've talked a good bit about this, but the Vertex study that's been mentioned fed into a study by the Center for Applied Research. And that study was called an analysis of the adequacy of financial assurance requirements for oil and gas infrastructure located on state, trust, and private lands in New Mexico.
Yes, I'm familiar with that.
Okay. And that's something I'm familiar with, being the representative from the land office. And what we found there was, that study cites $164 million in bonds being held at the land office, $5.173 billion in ultimate cleanup costs, P&A costs, with a gap to the land office of just over $5 billion. And those were 2020 dollars. So it could be $6 or $7 billion today. Just anything else you'd like to say about the Vertex study?
I am familiar with the study by the Center for Applied Research, and I thought it was a relevant, useful study.
Thank you. It's important to us too, because as fiduciaries for our state trust lands, at the end of the day, we over the decades, or maybe a century, we've been able to put aside $30-some billion in the Land Grant Permanent Fund, and we'd hate to see that be tapped someday, or have state funds, taxpayer funds, go to pay for something like $7 billion in cleanup costs on state trust lands when if and when the oil and gas industry wraps up in the state.
On a personal note, I agree with you. I would hate to see those gains lost.
Thank you, Mr. Purvis. No further questions.
Thank you.
Chair Chang?
I don't think I need to. That's okay. I was going to say I'm not going to belabor this witness anymore. I wonder if we're close to a break. Should we do that?
We are. It was just to you, and then, but do you have questions when we come back?
No, I don't.
All right, terrific. So I think we can excuse Mr. Purvis, yes? All right, thank you very much, Mr. Purvis. Let's take 10 minutes. Let's see, come back at 2:35. from the break, please?
Thank you for the insight.
All right, we are back after a short break. Let's see, Ms. O'Grady?
Good afternoon. My name is Morgan O'Grady for the applicants, and we call our next witness Peter Morgan. And
Thank you.
I'd like to share my screen, please.
All right. Would you please spell your first and last name?
Sure, it's PeterMorgan.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Ms. Grady.
Give me just a moment to get them set up.
Commissioners, in your exhibit books, Mr. Morgan's testimony on direct is Exhibit 15.
Mr. Morgan, please state your name.
Peter Morgan.
Where are you employed and what is your position?
I am Legal and Policy Director for the Center for Asset Retirement Accountability, or CARA, whose mission is to address the national problem of unplugged oil and gas wells, including through regulatory solutions. My work involves understanding existing regulatory requirements at the federal and state level, identifying gaps and flaws with those requirements that lead to the creation of additional orphaned wells, and proposing solutions to address those gaps and flaws.
What is your educational background?
I have a Bachelor of Arts from Middlebury College. I have a JD from Stanford Law School and a Master of Science from Stanford's Interdisciplinary Program in Environment and Resources.
Can you briefly describe your work background?
Prior to my current position with CARA, I worked for 16 years as an attorney for the Sierra Club, focusing on issues around the operation and cleanup of fossil fuel extraction facilities nationwide, with a concentration on oil and gas operations and coal mines. Through this work, I have expertise in understanding the strengths and weaknesses in state and federal regulatory requirements for financial assurance from oil and gas operators failure to comply with regulatory requirements and best practices, and the fiscal, environmental, and public health problems resulting from orphaned and abandoned wells across the nation, including in New Mexico. I testified before Congress at a 2023 hearing of the House Subcommittee on Energy and Mineral Resources on the need for improved regulations to strengthen financial assurances, restrict transfer of obligations, and address other issues related to cleaning up fossil fuel extraction sites.
Is applicant's Exhibit 14 an accurate copy of your resume?
Yes.
Mr. Morgan, you supplied direct and rebuttal testimony on behalf of the applicants in this matter, applicants Exhibits 15 and 81 respectively.
Yes.
Is that testimony accurate to the best of your knowledge, and do you adopt it?
Yes.
In broad terms, what opinions will you provide?
I will provide opinions on applicants' proposed amendments to 1915-2 NMAC, providing a definition for marginal well, 1915-5 NMAC, addressing well plugging requirements, 1915-8 NMAC regarding financial assurances, and 1915-9 NMAC regarding OCD's review of applications for operator registration and change of operator at well transfer. Overall, my recommendations are intended to help prevent wells being orphaned without adequate financial assurance in place to provide for plugging.
My goal is to encourage the timely plugging of wells by operators and ensure OCD has access to adequate resources to plug any wells that have been orphaned.
Are current oil and gas regulations in New Mexico adequate to ensure appropriate and timely plugging of oil and gas wells?
No. Unfortunately, New Mexico's current regulations allow oil and gas operators to delay and avoid meeting their asset retirement obligations. The result is that landowners and communities must contend with unplugged inactive wells, many of which leak or pose other threats to human health and the environment. When operators go out of business without completing plugging, the responsibility and associated costs get passed to the state. Because financial assurances for well plugging are far below actual costs, the state must use funds from other sources to pay for plugging. Meanwhile, the oil and gas industry continues to enjoy substantial profits. Operators often take advantage of New Mexico's weak regulatory provisions to transfer the wells and associated cleanup obligations to less resourced operators who are much more likely to go out of business and pass the cleanup costs on to the public. The New Mexico Legislative Finance Committee recently issued a policy spotlight orphaned wells report. LFC found that there are currently 700 non-producing wells in New Mexico that will not be plugged by their operator and will instead need to be plugged by the state, and another 2,100 non-producing wells the state will likely need to plug. The actual figure is almost certainly at the higher end of that range. Although New Mexico does not have a statutory or regulatory definition for the term, these can be understood to be orphaned wells. LFC reports, based on its review of OCD invoices, the average cost for OCD to plug a well in fiscal year 2024 was $163,000. It will therefore cost the state between $114 million and $342 million just to plug this existing inventory of orphan wells. This does not include site remediation costs, which can be much higher. New Mexico's Reclamation Fund will not cover these costs, which will include site remediation costs, because as of April 2025, the fund contained just $66.7 million. These figures do not include the additional thousands of wells almost certain to be orphaned in coming years. New Mexico has approximately 63,000 wells that are currently unplugged and will eventually need to be plugged. Of these, approximately 3,765 wells were on the OCD inactive well list as of July 3rd, 2025. In addition, according to LFC, quote, there are more than 3,000 wells on state or private land producing extremely small quantities of oil and gas, whose expected cleanup costs far exceed their predicted future revenues. These inactive and low-producing wells are at high risk of orphaning, particularly when transferred to under-resourced operators, including operators who already hold a large number of inactive and low-producing wells.
Are there specific deficiencies in the current rules?
Current New Mexico regulations contribute to and precipitate this present and growing orphan well crisis in three ways. First, the current regulations allow operators to delay and avoid plugging by allowing wells to be placed in temporary abandonment status without any demonstration the wells have future beneficial use. Second, because current financial assurance requirements are set far below actual plugging costs, the rules do not provide an incentive to operators to timely plug wells in order to be released from financial assurance obligations. The lack of adequate financial assurances means that when the wells are orphaned, essentially all the plugging and remediation costs must be borne by the state. Third, the current regulations facilitate and encourage the practice of transferring inactive and low-producing wells away from the operators who profited from their earlier production. OCD lacks the information and authority to take meaningful action to scrutinize and reject proposals to transfer inactive and low-producing wells to under-resourced operators most likely to orphan those wells rather than plug them. Applicants' proposed amendments address all of these issues.
Turning to applicants' specific proposals, applicants propose to amend 1915-59A and MAC enforcement and compliance. What is the purpose of this section and what amendments are proposed?
This section lists criteria for a compliance determination for purposes of certain regulatory actions in the rules, including whether to release financial assurances and whether to approve operator registration and change of operator. First, the proposed amendments would eliminate existing language allowing operators to maintain a specified number of wells out of compliance with well plugging requirements. The proposed amendment restores needed clarity by requiring that all wells must be plugged when plugging obligations are triggered. This does not leave operators without recourse for a well that may be returned to service because the existing regulations already allow an operator to secure designated temporary abandonment status for such a well. Second, the proposed amendments would add an additional criterion requiring operators to meet the requirements for venting and flaring of natural gas at wells. Operators who regularly vent and flare natural gas in violation of regulatory requirements may also lack capacity to properly operate and plug their wells, and the inclusion of the reference in the compliance provisions provides OCD with the opportunity to address these operational deficiencies and to determine whether the operator has the resources and ability to assume additional well operating and plugging obligations.
Before you discuss applicants' specific proposals to amend financial assurance requirements, could you discuss the role of financial assurance in general and the problems that arise when financial assurance is not adequate?
Before an oil or gas well is even drilled, it's known that one day it will stop producing in economic quantities and must be plugged. The nature of oil and gas operations is that the obligation to plug comes due at the point when the well has stopped generating revenue. Plugging and decommissioning is expensive and represents a pure cost with no potential to produce additional revenue. This stark economic reality increases the likelihood that an operator will go out of business or otherwise walk away from its obligations before completing plugging. At that point, even if the regulator were to sue the operator would be effectively judgment-proof, with no assets left for the regulator to claim. This risk increases the more inactive wells an operator holds. Regulators can address this dynamic by requiring operators to post financial assurances prior to drilling or acquiring operating authority over a well, sufficient to cover the costs of plugging, or at least sufficient to shift the incentives so that the operator prioritizes well plugging. Effective financial assurance programs facilitate timely and effective decommissioning in three ways. First, the financial assurance assures that some resources will be available for reclamation if the operator fails to clean up the site. This financial backstop is particularly important in industries such as oil and gas extraction that are subject to boom and bust cycles that can lead operators to drill wells when prices for oil and gas are high, but can contribute to bankruptcies when prices are low. Second, effective financial assurance creates an incentive for the operator to complete the plugging as soon as the well is no longer economic by imposing ongoing costs, annual premiums, and collateral requirements that are only released once plugging is complete. The desire to free up capital and avoid these ongoing costs should offset an operator's desire to avoid or delay the cost of plugging. Third, financial assurance requirements shift risk away from the state and onto a third party, such as a surety bond provider, which conducts its own analysis of an operator's reliability and likelihood of default. Financial assurance providers screen operators and set premiums and other fees based on observable indicators of factors including regulatory compliance and the number of non-producing wells held by the operator.
Under current regulations, what percentage of plugging costs for orphaned wells are covered by forfeited financial assurances in New Mexico?
Almost none. According to OCD's annual reports on the Reclamation Fund for fiscal years 2019 through 2024, although OCD expended $15 million plugging 193 wells, it recovered only $250,000 from financial assurance forfeitures, salvage, and recovery from operators. That works out to only 1.6% of total plugging costs recovered by the state. In 3 of the 5 years analyzed, OCD recovered $0. LFC found that OCD has not successfully redeemed any financial assurance since 2018. This dramatic gap is attributable to the fact that the low amounts recoverable via bond forfeiture may lead OCD to conclude that it is not worth the time and effort to complete bond forfeiture.
Why is it important to maintain policies that promote prompt plugging of non-producing oil and gas wells?
Unplugged oil and gas wells can leak numerous harmful pollutants into the air and water. Pollutants may escape when the well casings or well heads of unplugged wells rust or crack, which can happen over time through corrosion, improper maintenance, subsidence, or from other causes. Oil and gas wells can emit air pollutants, including methane, nitrogen oxides, sulfur dioxide, and hazardous air toxics like benzene, toluene, ethylbenzene, and xylene. These pollutants are known or suspected to cause cancer or other serious health effects, such as reproductive diseases or birth defects. Methane leaks are a particular concern from unplugged wells because at high levels, methane can pose an asphyxiation and explosion risk and is a potent greenhouse gas driving global climate change. Researchers have observed increased concentrations of air pollutants at distances of 4 kilometers downwind of wells. Leaking wells can also pollute groundwater and surface water, including contaminating drinking water sources. Oil and gas well bores pass through shallower strata that may contain groundwater used for drinking or other purposes. Unplugged, non-producing wells can facilitate migration of pollutants from deeper hydrocarbon-producing strata into this groundwater or up to the surface. The communities most likely to be exposed to pollutants from unplugged oil and gas wells include historically marginalized groups. This includes communities in northwest New Mexico living in close proximity to a high density of wells. Proximity to wells is associated with a range of negative health outcomes, including increased risk of cancer, birth defects, and cardiac and pulmonary impairment. Wells that are plugged have roughly 100 times lower average emissions than wells that are unplugged. The longer a non-producing well sits idle, the more opportunity there is for air, land, and water pollution. Wells that already leak will produce more pollution, and non-leaking wells may deteriorate to the point where they begin to leak.
Does inadequate financial assurance impact regulators' decision-making?
Yes. When financial assurances are set too low, regulators may become wary of taking any form of enforcement action, including enforcing plugging requirements, out of concern that such actions will push the operator toward bankruptcy. When financial assurances are adequate, regulators are free to enforce regulations without concern that an operator could respond by filing for bankruptcy.
How much does it cost OCD to plug a well in New Mexico?
LFC, reviewing invoices for OCD-directed plugging, has reported the average plugging cost for fiscal year 2024 as $163,000 per well. Other calculations of well plugging costs in New Mexico have resulted in similar or higher figures. In its 2021 Notice of Intent to Apply to the U.S. Department of the Interior for Orphaned Well Plugging Program grants, OCD reported spending an average of $167,000 per well. In its 2024 Phase 2 work plan proposal to DOI, OCD reported recent average plugging costs of $180,000 per well.
How do these actual plugging costs compare to the financial assurance levels in New Mexico's current regulations?
Currently, financial assurance amounts in New Mexico fall far below the average cost to plug a well. Under the existing regulations, single well financial assurances are expressed in terms of the depth of the well as $25,000 plus $2 per foot of the projected depth of a proposed well or the depth of an existing well. For even a 10,000-foot well, that would equal only $45,000 in financial assurance, less than a third of the actual average plugging cost. The current blanket bonding provisions allow for significantly lower financial assurance amounts. The currently allowable blanket bond for an operator with 100 active wells is $125,000, working out to just $1,250 per well. If an operator with 100 wells were to default and orphan its wells, the shortfall between the bonded amount and the well plugging cost using the $160,000 average would be $16,175,000.
Turning to applicants' specific proposals for 1915-8 NMAC governing financial assurance, what amendments do applicants propose to subsection 1915-8-9A NMAC, setting forth the scope of applicability of the part?
Applicants propose adding the sentence, quote, "The division shall not approve and the operator shall not proceed with any proposed drilling or acquisition until the operator has furnished the required financial assurance." This amendment prevents a situation where an operator may incur a plugging obligation by drilling or acquiring operating authority over a well before it has provided the required financial assurance. Under that scenario, there would be a chance that the operator could then default on its obligation and there would be no financial assurance available to OCD to put toward the cost of finishing the work and plugging the well.
What amendments do applicants propose to financial assurance requirements for active wells at 1915-8-9 NMAC?
The proposed amendments would increase the one well financial assurance amount for active wells to $150,000 and would set all blanket financial assurances to the statutory maximum of $250,000. The Oil and Gas Act requires OCD to, quote, "establish a one well plugging financial assurance in amounts determined sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance." A one well financial assurance of $150,000 per well closely approximates an amount sufficient to reasonably pay the cost of plugging the wells. OCD's average cost to plug a single orphan well is $163,000. And while there will always be some variation in actual plugging costs from well to well, it's reasonable to use a figure close to the average plugging cost. And because the vast majority of operators maintain multiple wells, this averaging is likely to work out across the operator's well inventory. Although the use of a $150,000 per well figure is still likely to result in a gap between financial assurance amounts and actual plugging costs, the significantly smaller scale of this gap can be addressed through use of the reclamation fund. In contrast, the current approach to calculating a one well financial assurance, the $25,000 plus $2 per foot of the well's depth, is not sufficient to reasonably pay the cost of plugging the well. In almost all cases, actual plugging costs will far exceed a financial assurance calculated on this basis. While the Commission must consider the well depth in setting financial assurance amounts, There is no statutory requirement that the financial assurance amount be directly pegged to the depth of the well. Furthermore, the primary cost drivers in well plugging are not related to the depth of the well. Much more important are factors including the condition of the well and issues related to access to the well. All of these cost factors, including well depth, are inherently incorporated into the $150,000 based on average plugging costs, but are not captured by an approach based purely on one variable, well depth. The proposed amendments would also replace the current scaled approach to calculating blanket financial assurance amounts for active wells with a single blanket financial assurance set at the statutory maximum rate of $250,000.
What is the basis for the new financial assurance category for marginal wells?
OCD first proposed this category. Marginal well is defined under the proposed amendments as, quote, an oil or gas well that produced less than 180 days and less than 1,000 barrels of oil equivalent within a consecutive 12-month period. Such marginal wells pose a significant risk of being orphaned because the revenue they will produce over their remaining production may be less than the cost of plugging and remediating the well. This creates a powerful incentive for operators, particularly new operators who did not enjoy the original profitable period of higher production, to avoid these costs. The proposed definition of marginal well includes components related to both the amount of production and the number of days the well produces. Each component is critical. The total amount of production relates directly to the revenue generated by that well. The number of days producing is also important because operators can manipulate well production to make wells appear artificially productive, but only over short periods of time, giving a false impression that a well is economic when it is not. According to Mr. Purvis's analysis, approximately 2,200 wells would be categorized as marginal wells under the new rules, exclusive of wells presumed not to have beneficial use, constituting 3.7% of the well population and 0.045% of production. The proposal recognizes that marginal wells carry a high risk that should be reflected in the amount of financial assurance the state requires to protect against the well becoming orphaned. The phased-in approach proposed by applicants gives operators with existing marginal well inventories currently covered under blanket financial assurances until January 1st, 2028 to plug these wells, return them to a higher level of production so the marginal well financial assurance requirement no longer applies, or secure individual well financial assurances. The one well financial assurance would apply immediately for any marginal well being transferred to a new operator, recognizing that transfer of low-producing wells to under-resourced operators is a major contributor to well orphaning. The transfer requirement also precludes operators from avoiding the January 2028 deadline by transferring away their marginal wells rather than plugging them or providing the one well financial assurance. At least two other states, Arkansas and California, require operators to provide one well plugging financial assurances at the time a low-producing well is transferred. The proposed amendment represents a common sense approach to financial assurances for low-producing wells at the time of transfer, consistent with the approach already employed by other states.
What is the basis to require an operator with over 15% of their wells in marginal and/or inactive status to provide a one well plugging financial assurance of $150,000 for all of their wells?
Operators with a significant proportion of marginal and inactive wells pose a heightened threat of failure because they may not be able to generate sufficient cash flow to meet their well plugging obligations. Operators with a higher proportion of marginal and inactive wells generate less revenue. At the same time, they face higher costs from plugging. Requiring a one well financial assurance set an amount pegged to the actual cost of plugging to OCD is not a penalty imposed on operators. It is a common sense means by which the state can protect its own interests and those of its residents. Financial assurances set at levels at or near the actual cost of plugging protect the interests of the state by providing a financial backstop in the event of operator default and providing an incentive for operators to complete timely plugging. Some jurisdictions, including New Mexico, have made the determination that such protections and incentives are not necessary for certain types of operators. Some operators, the theory goes, generate sufficient ongoing revenue that they should not have any trouble covering their plugging costs and therefore represent a low risk of default and do not require a full financial assurance backstop. This is a benefit extended to certain operators, which must be weighed against the corresponding increased risk borne by the state. The logic underlying the policy of allowing certain operators to provide less than adequate bonding simply does not hold for operators who have more than 15% of their wells inactive or producing at only marginal levels. Such operators face the simultaneous pinch of reduced revenues at the same time they faced increased immediate plugging costs. The proposed amendment discourages operators from specializing in the acquisition of low-producing wells. Such operators who take this approach may be betting on a dramatic increase in commodity prices that would render their wells profitable, or maybe betting that they can pocket whatever remaining revenue their wells can produce while avoiding the plugging costs. In either case, the state and public monies should not be compelled to underwrite this risk.
Why is it necessary to increase the required bonding for inactive wells and wells in approved and expired temporarily abandoned status, as applicants propose?
By increasing the bonding required for inactive wells and wells in TA, the proposed amendment ensures that New Mexico will have adequate financial assurances for the categories of wells at highest risk of being orphaned. The Interstate Oil and Gas Compact Commission, a body representing and made up of state regulators, has specifically highlighted the risk of well orphaning posed by inactive wells and by operators with a high percentage of inactive wells. In a 2021 report, the IOGCC noted that, quote, "The number of idle wells in a state or province is a concern because of the potential for the wells to deteriorate over time or become orphans. An even more critical factor is the number of idle wells held by an individual operator, especially as a percentage of the operator's total wells that have been drilled but not plugged. A high percentage of idle wells may indicate an increased vulnerability of the state or province to the operator becoming insolvent and leaving orphan wells. States and provinces use various approaches to ensure operators actively manage their idle well inventories and plug wells with no future beneficial use. The proposed amendment is therefore in line with regulations of many other oil and gas producing states. The New Mexico legislature has already recognized that wells in TA inactive status represent a higher risk by setting a minimum blanket bond amount of $50,000 for wells in TA status, but there is no maximum, and by requiring a one well financial assurance on any well that has been held in a temporary abandonment for more than 2 years.
Why do the proposed amendments restrict the use of blanket financial assurances for some categories of wells?
Under the proposed amendments, blanket financial assurance where the per well coverage varies depending on the number of wells, is only available for active wells. Financial assurances for all other categories of wells are calculated based on a per well cost of $150,000, including under the blanket financial assurance in subsection E for inactive wells and wells in approved and expired TA status. These changes are appropriate because these wells have the greatest chance of being orphaned. Imposing individual well financial assurance requirements for these wells should lead operators to plug these wells sooner to avoid ongoing fees and carrying costs required to maintain those bonds. The first problem with blanket financial assurances is it results in a very limited per well coverage. Under the amounts in New Mexico's financial assurance regulations, coverage under a blanket financial assurance can be $1,250 per well or even lower. That's less than 1% of OCD's actual average plug-in cost of $163,000. When an operator who's provided only a blanket financial assurance defaults and orphans its wells, almost all of those plug-in costs must be covered by the state. Blanket financial assurances provide very little incentive for operators to plug their wells as they cease producing. This is because when an operator plugs a well covered under a blanket financial assurance, it does not receive a corresponding decrease in the carrying costs associated with maintaining the blanket financial assurance. Instead, the operator continues to pay the same costs to maintain the same blanket financial assurance for its remaining wells. This encourages operators to delay plugging these wells, potentially until all wells covered under that blanket financial assurance have stopped producing. Blanket bonding also poses a high risk because bankruptcy occurs at the operator level, not the individual well level. So, when an operator defaults, all of its wells, particularly its inactive and marginal wells, are likely to be orphaned. This poses only a minimal problem for the regulator when those wells are all covered by individual bonds, but it poses a massive problem when those wells are covered by a single blanket financial assurance.
Why do applicants propose expressly including approved and expired temporarily abandoned wells in 1915-8, 9E, and MAC?
The proposed amendment provides better consistency between the language of the regulation and the language of the statute. The statute expressly references wells in temporarily abandoned status. The current regulations omit several important categories of inactive and temporarily abandoned wells, including 1, wells that are inactive but for which the operator has not sought temporarily abandoned status, 2, wells that have received approved temporarily abandoned status but have been in this status for less than 2 years, and 3, wells in expired temporarily abandoned status. The proposed amendment closes this gap by expressly including such wells among the categories of wells to which the financial assurance requirements of 1915-8-9E and MAC apply.
Will increased financial assurance requirements harm small businesses and hurt New Mexico's economy?
The experiences of regulators in other jurisdictions make clear that increasing financial assurance requirements leads to decreases in well orphaning and better environmental compliance among operators, with no or minimal impact to overall oil and gas production in the state. The economic analysis by Boomhauer of the effect of the 2001 increase to Texas's financial assurance requirements for oil and gas producers concluded that, quote, despite affecting small firms, the bond requirement yielded large environmental improvements because small producers caused a disproportionate share of environmental problems. The bond requirement reduced the industry-wide orphan well rate by 65%. The study also found that the new financial assurance requirement had a negligible impact on production. Quote, Notably, the state's total output of oil and gas was essentially unaffected by the policy. This is because the firms affected by the policy accounted for a small fraction of production, and because most of the valuable production associated with exiting firms was reallocated to other producers instead of shutting down. A separate study looking at the effects of changes to oil and gas regulations in North Dakota, including increased financial assurance requirements, observed nearly identical results. The study found, quote, no statistical change in the pace of drilling wells after the North Dakota regulations came into effect, and that, quote, the reduction in production for small operators in North Dakota after the regulation went in effect relative to production in Montana is about 0.5%. Although the Texas and North Dakota laws reviewed in the two studies required bond amounts that are lower in absolute terms than the adjusted financial assurance amounts in the proposed amendments, each law represented a significant increase compared to prior requirements. I believe the proposed amendments would have a similar effect in New Mexico. Irresponsible operators may be pushed out of the market, but the overall impact to the industry and overall production will be small, and the companies who continue to operate will have better compliance records.
If financial assurance amounts are increased, will the full cost of the increases be borne by operators?
Most operators satisfy financial assurance requirements by posting surety bonds. Surety bond providers charge an annual premium, typically between 1% and 5%. Note that in my original direct testimony, I cited a range of between 1% and 2.5%. Industry witnesses provided an updated range based on recent data, and I incorporate that here. Surety providers may also require operators to pledge collateral, which would be released once the well is plugged and the bond no longer needed. These are costs to the operator, but amount to less, often far less, than the face value of the bond. The surety bonding industry is the competitive market with multiple providers competing for the business of operators. Surety providers set the terms of individual bonds depending on the risk of default they perceive from the operator, balanced against the risk that a different provider will offer more favorable terms. To the extent an operator may only be able to secure a bond under onerous terms with higher premiums and more collateral required, this is a clear signal that the surety industry perceives that operator to represent a high risk of default. Such operators also pose a high risk to the state's interests in that they are more likely to default and orphan wells and to pose other compliance problems. If the market makes it difficult or impossible for such operators to secure the bonds needed to operate, that is to the benefit of New Mexico by protecting the state against high-risk operators.
Why do applicants propose to provide for adjustments to financial assurance requirements based on inflation?
It's widely recognized that plug-in costs increase over time, including as a result of inflation. In a 2021 report, the IOGCC noted that, quote, plugging and restoration costs rise over time due to inflation, and in some cases due to improved and more stringent regulatory requirements for materials and methods. The Federal Bureau of Land Management, in its recent rulemaking increasing bond amounts for wells on federal land, similarly cited the role of inflation in necessitating adjustments to financial assurance amounts. And Wyoming's regulatory bonding requirements for oil and gas wells provide that bond amounts shall be, quote, adjusted every 3 years based on the Wyoming Consumer Price Index or actual plug-in costs.
In addition to the financial assurance requirements, New Mexico maintains the Reclamation Fund. Why not just rely on the Reclamation Fund to make up any shortfall rather than amend the financial assurance requirements?
There's simply not enough money in the Reclamation Fund to cover the shortfall between existing financial assurance levels and the current and anticipated inventory of orphan wells. According to LFC, the Reclamation Fund contained $66.7 million as of April 2025. LFC further estimates the state's potential liability far exceeds that total, finding that, quote, altogether, the state's current and near future liability for well plugging and site remediation is estimated at $700 million to $1.6 billion. Some of the plugging costs for those existing orphan wells may be covered by federal funds administered by DOI under its orphan well plugging program, but not nearly the full amount. LFC lists New Mexico's total federal funding eligibility as $167.3 million. Accordingly, federal funds will not cover the shortfall. Relying on the Reclamation Fund to cover the costs of plugging newly orphaned wells also creates a negative incentive and moral hazard for operators. If operators know OCD will not seek to enforce plugging requirements and will not seek to recover plugging costs from operators themselves, this will create a powerful incentive for operators to continue and even increase the practice of orphaning wells to OCD. Why would an operator choose to bear the cost of plugging a well itself if it knows that its competitors are avoiding that cost category?
Applicants propose a number of changes to the change of operator rules at 19.15.9.9 NMAC. Before you discuss the specific amendments, can you describe the increased risk of well orphaning that is associated with well transfer?
Well transfers, particularly of inactive marginal or other low producing wells, dramatically increase the risk that the well will be orphaned. This is because such transfers create a separation between the operator who profited from the well's highest production and the operator who must bear the cost of plugging and decommissioning the well. Often, at the time a low producing well is transferred, the remaining revenue the well will generate will be less than the cost of plugging and decommissioning that well. The economics of the transfer of such a well only make sense if the transferee operator can avoid the cost of plugging. And yet, such transactions regularly occur. A variety of oil and gas regulators have recognized the risk of orphaning inherent in the transfer of low-producing wells. The IOGCC has found that, quote, it is common for operators to transfer wells and associated facilities and pipelines to other companies. State and provincial regulators have a special concern with transfers of wells with declining production because of the increased risk that such wells may become orphans. Many states and provinces have implemented measures to reduce this risk by setting additional requirements for financial assurance and by evaluating corporate solvency and compliance history and the status and condition of the wells and associated facilities and pipelines before approving a transfer. An effective regulatory program for oil and gas operations must include provisions addressing the transfer of wells, particularly inactive, marginal, and other low-producing wells.
Why isn't it sufficient to just increase the amount of financial assurance required as other parts of the proposed rulemaking do?
In theory, a fully effective financial assurance program would address the primary risks posed by the transfer of inactive, marginal, and other low-producing wells. The proposed changes to financial assurance requirements in this rulemaking are a step in the right direction, but still fall short of what would be required. Several factors prevent New Mexico from maintaining a fully effective financial assurance program at this time. These include, 1, average plugging costs are just that, an average. Some number of wells will have actual plugging costs that exceed the average. 2, financial institutions, including the providers of surety bond coverage, may fail. This risk is particularly high for surety bond providers who specialize in providing financial assurances for the oil and gas industry. And 3, New Mexico statute currently places limits on the state's authority to require full cost financial assurances, including by allowing blanket bonding for some wells, but capping the coverage amount. An effective regulatory program designed to prevent the creation of additional orphan wells will both require adequate financial assurances and restrictions on the transfer of wells. A peer-reviewed economic study of the law and economics of reclamation bonding found that compliance with plugging requirements, quote, can be induced with bond levels that are below the expected reclamation costs if regulators have the authority to block permits for any operator that has a record of non-compliance.
Let's turn to 1915-9 NMAC, well operator provisions. What is the general purpose of this section, and what amendments do applicants propose?
This section governs OCD's registration and approval of new operators and changes of operator for specific wells, essentially well transfers. It specifies the types of information OCD may collect when considering operator applications and provides the grounds on which OCD may deny an application. This section therefore authorizes OCD to evaluate the qualifications and capacity of an operator to meet the requirements of New Mexico's oil and gas program. The proposed amendments add a new criterion for approval of initial operator registration. After I submitted my direct testimony, applicants and OCD engaged in discussions with OCC regarding this amendment and negotiated changes to the original proposal with OCC. Under the updated proposal, an applicant would have to disclose whether it is subject to any forfeiture demands from a state or federal agency, has forfeited financial assurance to a state or federal agency, or has any unresolved adjudicated orders or unresolved settlement agreements for any state or federal violations. OCD would also be authorized to deny operator registration on this basis. The required disclosure is important because many oil and gas operators do business in multiple jurisdictions. OCD currently has the capacity to track operator compliance at wells and sites within New Mexico, but has no means to efficiently collect that information outside the state. OCD should be able to know if an operator has a past history of forfeiture and non-compliance at its facilities out of state. Among other things, this is necessary to prevent bad actor operators from seeking refuge in New Mexico after running afoul of regulators in other jurisdictions. More fundamentally, it allows OCD to gauge the likelihood of an operator's capacity and willingness to satisfy the obligations associated with operating oil and gas wells in New Mexico. The proposed amendment also requires operators to disclose officers, directors, partners, and persons with an interest in the new operator exceeding 25% who are or have been within the previous 5 years part of a company not currently in compliance with the well plugging requirements of 1915-59 NMAC. This prevents individuals who incurred violations at one company from walking away from that company and its liabilities and starting a new company or seeking operator status as an individual. The approach of tracking officers, directors, and other interested parties across companies is common in the regulation of resource extractors. For example, the Federal Surface Mining Act prohibits issuance of a new permit to any applicant who owns or controls mining operations having unabated or uncorrected violations anywhere in the United States until those violations are abated or corrected or are in the process of being abated or corrected. And DOI maintains a national applicant violator system to track these violations. The proposed amendment also expands the existing regulatory provision, allowing OCD to require an operator to disclose its current and past officers, directors, and partners, and its current and past ownership interest in other operators. The proposed amendment would make such disclosures mandatory, specify the form of disclosure as a certification, and require operators to update that certification annually.
What amendments do applicants propose to applications for change of operator?
The proposed amendment requires the same certification regarding the operator's history of forfeiture in other jurisdictions and tracking the compliance history of associated entities that also applies to new operator registrations. And it also requires change of operator applicants to provide a certified plugging and abandonment plan. The justification for the certification of the operator's forfeiture record and the compliance history of associated entities is the same as for the amendments pertaining to new operator registration. The same rationale applies to applications for change of operator associated with well transfers. The plugging and abandonment plan requirement is necessary to prevent the scenario where a new operator plainly lacks the resources to satisfy the plugging obligations it is assuming. For existing operators who may already hold inactive and marginal wells, it allows OCD to consider those existing plugging liabilities in addition to the new liabilities being assumed through the proposed transfer. It also allows OCD to verify an operator's claims that future production from existing wells and the wells to be transferred will be adequate to produce revenue sufficient to satisfy the operator's aggregate plugging obligations. It also allows OCD to consider the new operator's actual history of compliance and success at eliciting additional production from wells other operators consider spent, including the operator's history of inactive wells and returning wells to production. These amendments authorize OCD to take appropriate action when a proposed transfer of wells raises questions about whether the new operator will have the resources and capacity to actually satisfy the well plugging obligations it is assuming.
Why is it appropriate for OCD to consider factors including a transferee's financial condition?
When OCD issues a permit or approves a transfer, it is effectively extending credit to the operator because OCD is assuming the ultimate responsibility to ensure well plugging. This is just the same as the credit a bank extends to the holder of a credit card. If you don't pay your credit card bill, the bank is still obligated to pay the vendors for the charges you made. And just as a bank considers an applicant's credit score and other indicators of creditworthiness before issuing a credit card or a mortgage, OCD, as the issuer of credit, must be able to ensure the creditworthiness of the operator.
What amendments do applicants propose to 191599E and MAC?
The proposed amendment focuses on the conditions of the well rather than the operator, and prohibits transfer of wells that are overdue for plugging or have unaddressed spills or otherwise have outstanding remediation needs, unless OCD determines that the well is in compliance or there is an approved schedule of compliance. Transfer of a well can dramatically increase the chances of that well being orphaned. That is particularly true for wells with higher remediation costs or with plugging and remediation obligations that are due immediately before the well can generate any revenue to offset those costs. The proposed amendment creates an opportunity for OCD to monitor the status of the wells to be transferred and to take steps to minimize the chance of those wells being orphaned.
Thank you for that summary of your direct testimony. We will now move to your summary of rebuttal testimony. And Madam Hearing Officer, I'd like to pass out Exhibit 88.
Thank you.
Thank you. Mr. Morgan, do you have any general comments at the outset about the direct testimony filed by the industry parties in this matter?
Significant portions of the testimony of NMOGA and IPA&M experts confirm the fundamental premises identified by applicants that establish the need for the proposed amendments. And yet, only applicants proposed solutions to these problems. Industry experts acknowledge that oil and gas production in New Mexico has entered its decline phase. Mr. McGowan states, quote, "The likelihood that Permian shale production has already peaked is more than just speculation. It is becoming the prevailing leitmotif for the industry's evolving dynamics, close quote. This decline means that action must be taken immediately to ensure that existing revenue from these wells is put towards satisfying plugging obligations. Industry experts also acknowledge that the practice of transferring low-producing wells from highly profitable initial producers to under-resourced small operators is a fundamental part of the industry's business model. Mr. McGowan describes the role small operators play in, quote, de-risking legacy assets that the larger companies no longer prioritize, close quote. Under the current rules, that risk is passed to the state. Industry experts also all but conceded that operators of marginal wells have not set aside funds to cover the costs of plugging their wells and do not have the resources to satisfy those obligations. Mr. Emmerich states, quote, for these sizes of operators, working capital and investment capital are generally minimal. The minimal working capital referenced includes the capital needed to plug wells. Industry witnesses state that operators are unlikely to be able to satisfy surety provider requirements that they have working capital equal to 25% of a $150,000 bond. That's just $37,500 per well. Industry experts cite to the Ramey study, which provides a national median plugging and remediation cost of $76,000. Even assuming that figure is accurate, that means New Mexico operators maintain working capital per well of less than half of that plugging cost and 1/4 of OCD's average cost of $163,000 per well. The available working capital is even insufficient to cover the plugging costs of $40,000 to $60,000 per well cited in Mr. Arthur's rebuttal testimony. In other words, operators do not have the capital to plug their wells. That means the cost of plugging these wells will fall to the state. Finally, industry experts implicitly acknowledge that the surety bonding industry has concluded that under the current rules, New Mexico oil and gas operators pose an extremely high risk of defaulting on their plugging obligations. Mr. Gilstrap states, quote, currently we are in one of the hardest surety markets I've experienced in my career. Mr. Emmerich states, quote, the simple fact is that the surety market today is very demanding and difficult to navigate. Surety companies have become more restrictive in their underwriting guidelines to minimize the risk that a bond will be called, close quote. Surety providers are sophisticated, profit-motivated firms. To the extent sureties are imposing stricter collateral requirements, it is because of the risk they see from marginal operators in New Mexico. If sureties perceive these risks, then New Mexico's regulators must also, and must take immediate action to protect the state from defaults. Even if industry parties fail to expressly acknowledge the existence of the orphan well crisis in New Mexico, they have acknowledged each of the dynamics that has led to the crisis. This means the only remaining question for the Commission is what steps to take to address this crisis.
Before we turn to applicant-specific proposals, can you address general concerns raised by industry witnesses regarding the ability of operators to secure surety bonds under applicants' financial assurance proposals?
New Mexico must ask why an operator wouldn't qualify for a surety bond that covers the anticipated liability. Wouldn't the surety want to collect premiums? When determining whether to offer bonds and on what terms, sureties consider factors such as the remaining revenue in the operator's wells, the operator's expenses, and the operator's cash reserves. If a surety declines to issue a bond or requires higher premiums or higher amounts of collateral, That means the surety has concluded that that operator poses a higher risk of default. That should sound an alarm, prompting more action from state regulators, not less. Furthermore, surety providers are unlikely to treat the entire oil and gas industry as a monolith. New Mexico operators who can demonstrate a history of plugging wells and setting aside funds for plugging should still have ready access to the surety market. To the extent the proposed amendments help identify the operators with the riskiest wells, that will only assist New Mexico's responsible operators. Those responsible operators should be able to acquire wells and continue production as the highest risk operators exit the market.
NMOGA witnesses claim the surety market isn't equipped to issue the volume of surety instruments that would be needed to comply with these rules. What is your response?
Surety bonding is a robust and sophisticated industry with hundreds of firms providing bonds for a wide range of industries, including oil and gas. There are 245 distinct surety providers on the U.S. Treasury Department's Circular 570, listing companies vetted by the department and deemed qualified to do business with the United States. Almost all those sureties are licensed to do business in New Mexico. Sureties are always happy to collect premiums. Sureties keep the premiums they collect, regardless of whether they ultimately pay out the bond. If the operator completes the plugging and the regulator releases the bond, the surety still keeps the collected premiums, which can be considered a pure profit. The larger the bond, the more premiums may be collected. And if the operator defaults, the surety can recover the bond amount on top of the premiums collected by foreclosing on collateral and filing a collection action against the operator. Given the established capacity within the surety bonding industry and the inherent desire to collect premiums, concerns about the ability of surety providers to satisfy an increased demand for bonding are overstated, at least for responsible operators.
IPA&M and NMOGA witnesses claim that the unintended consequences of the proposed amendments include premature plugging of marginal wells, bankruptcies, increased orphaning, increased bank debt, and operators exiting the state. What is your response?
These predictions are contrary to the actual outcomes described by Boomauer and Lang and Redlinger in their respective economic studies describing the effects of increased bonding in Texas and North Dakota. Those studies found no meaningful decrease in production following adoption of the increased bonding requirements. Specifically, Boomauer observed that, quote, the state's total output of oil and gas was essentially unaffected by the policy. This is because the firms affected by the policy accounted for a small fraction of production, and because most of the valuable production associated with exiting firms was reallocated to other producers instead of shutting down. I would expect to see the same in New Mexico. Although the Texas and North Dakota laws reviewed in the two studies required bond amounts that are lower in absolute terms than the adjusted financial assurance amounts in the proposed amendments, each law represented a significant increase compared to prior requirements. It is likely that certain high-risk operators will see a decrease in access to capital and may choose to exit the market. But it's not accurate to say that the industry as a whole will be impacted the same way. The financially capable operators who remain will be able to acquire and continue producing economic wells. To the extent any additional wells are orphaned following adoption of the proposed amendments, the changes to the regulations would not be to blame. These wells are likely already going to be orphaned, regardless of what action the commission takes. Operators of these wells have failed to set aside the funds necessary for plugging. The only question is timing. Under the current regulations, operators are encouraged to kick the can down the road, but the outcome will be well orphaning. To the extent the amended regulations accelerate this process, the amendments are merely exposing this reality and allowing the state to take action sooner to address the need to plug those wells.
NMOGA witnesses claim the proposed rules are a one-size-fits-all approach in contravention of the statute. What is your response?
In relevant part, the statute states, quote, "In establishing categories of financial assurance, the Oil Conservation Commission shall consider the depth of the well involved, the length of time since the well was produced, the cost of plugging similar wells, and such other factors as the Oil Conservation Division deems relevant," close quote. The listing of multiple factors, together with inclusion of the additional catch-all, such other factors as the Oil Conservation Division deems relevant, directs the Commission to consider relevant available information. And the ultimate mandate of the statute is that the one well plugging financial assurance be sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance. The proposed amendments fully satisfy the statutory requirements. Under the existing regulations, one well financial assurances are determined solely on the basis of a single statutory factor, the depth of the well. None of the parties opposing the proposed amendments have suggested that this existing regulation contravenes the statute by focusing on a single statutory factor. Nor have any of the parties offered testimony demonstrating that the current standard of $25,000 plus $2 per foot of well depth bears any relationship to actual well plugging costs. Indeed, under that formula, a 10,000-foot well would require only a $45,000 bond, or less than one-third OCD's actual average plugging cost of $163,000. The current approach of focusing solely on well depth fails to capture additional significant cost drivers, including the age of the well, how long since the well stopped producing, the condition of the well bore, and any challenges in accessing the well site. Those factors, including well depth, are inherently incorporated into the approach adopted in the proposed amendments, where the $150,000 one well financial assurance is based on OCD's actual average cost of plugging wells. This approach of relying on OCD's actual plugging costs is the most effective way to ensure that the one well plugging financial assurance is sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance.
NMOGA and OCC witnesses claim that OCD lacks the legal authority under the statute to require the large blanket bonding amounts that would be required under the proposed rule. What is your response?
Applicant's proposal does not conflict with any of the Act's requirements, including the requirement to establish a blanket plugging financial assurance capped at $250,000. Applicant's proposal still includes a $250,000 blanket plugging financial assurance for active wells. Applicants also propose additional categories of financial assurance, all of which come within the Commission's authority to establish different categories of financial assurance, and none of which are blanket bonds that exceed the statutory maximum. For the administrative convenience of operators, applicants and OCD propose that for marginal wells, an operator may furnish all necessary one well plugging and financial assurance in the form of a single instrument. Allowing a single instrument instead of multiple instruments for marginal and inactive wells does not turn the one well plugging financial assurance required into a blanket plugging financial assurance. There is an important distinction between a blanket plugging financial assurance and the allowance that an operator may satisfy its cumulative financial assurance obligations through a single instrument. Under the former, the operator is allowed to provide coverage for multiple wells at a fixed amount, such that as the number of covered wells increases, the per well coverage decreases. In contrast, under the single instrument approach, the total amount of financial assurance required is calculated, including both eligible blanket financial assurance amounts and one well financial assurance amounts, and then the operator secures a bond or other financial assurance instrument for that total combined figure. Just because an operator qualifies for use of a blanket financial assurance for some of its wells does not mean that the $250,000 cap applies to all of the financial assurances required for that operator.
IPA&M and NMOGA witnesses object to the proposed amendment, object that the proposed amendment preventing drilling or acquisition until the operator has furnished the required financial assurance is vague and broad and would inject a new pre-acquisition approval power. What is your response?
The hearing officer addressed a similar argument in her recent recommendation on the motion to dismiss, noting that the movements suggest insertion of the phrase operating authority to remove any confusion over the effect of this provision. Applicants support insertion of the phrase operating authority or related phrases at 3 points in section 19.589A NMAC, both in the proposed additional language and in existing portions of the provision.
Madam Hearing Officer, I object to this testimony from the witness. I know that there's a handout that was circulated on this rule. And I guess in my mind, this constitutes an untimely new rule. NMOGA has not had the chance to review it with industry. We have not received feedback from our experts. This has not been subject to public notice. And I think if applicants want to raise this in post-hearing arguments or something like that, that's fine. But that's based on the feedback of what we learned at the hearing. And I don't think it's appropriate for them to be providing these rule changes at this juncture.
So I invited them to do that in my recommendation. And I understand the commission didn't take a final action on the motion. But because the applicants and NMOGA and IPA&M, the movements of the motion seem to just be in agreement that this was the appropriate interpretation of this language.
Well, I'm not sure that that is a fair characterization of our position. I mean, operating authority is not a defined term.
Okay. Well, let me put it this way. I invited them to do this during their
Understood.
case. So I'm going to accept it, and the commission is going to have to decide what to do with it. You can certainly offer your response later, but truly, because my reading of both the applicant's legal argument and the movement's legal argument was that this is you all effectively agreed that this is what drilling and acquisition meant. It was not about real property. It was about operating authority. So, Ms. Fox, do you have anything to add?
We would just add that this is both within the scope of the rulemaking and responsive to NMOGA's filings.
That's my take as well.
Okay.
So if again, if you'd like to address this in the next 3 weeks before the hearing ends, that would be great. And I'm sorry if I misunderstood your argument. I actually thought you believed that this was the right language. In fact, at the top of page 6, is at the top of page 6 in your reply, I think you suggested exactly, well, now I'd have to find it.
Well, we offer that as a potential clarification, but, even still, this belies kind of the inherent problems with the rulemaking in terms of not getting industry feedback. And so, again, I feel like this is a new rule proposal that's in front of the commission. I understand you're admitting it over our objection, and the commission has the authority to assess this going forward. I guess at some point we will have some sort of oral argument on the motion to dismiss and the authority and all that kind of thing. But I just wanted to note our objection to this for the record.
All righty. So, Ms. O'Grady, I forgot to look at the time when Mr. Suazo raised his objection, and now we are on the cusp of public comment. How much longer would you have?
We have, I would guess, more than 10 minutes, so we're fine to continue after public comment.
All righty. So let's break then. I have just one person on the platform desiring to make public comment. And Sheila, can you say whether there are others reaching out to you on the platform? I think I see 2 more. Okay. And let me ask if there's anyone in the room here to offer public comment during the 4 o'clock session. No. All right. So Sheila, the Spanish interpreter sent a text asking that you unmute her so that in the event someone would like interpretation between English and Spanish, she can provide that.
She's on the platform. Her name is Lisa O'Grady, and she's unmuted now.
She is unmuted.
Yeah.
All right, Lisa, you're unmuted.
May I
Right,
test just to see if I can be heard?
I can hear you.
Perfect. Thank you.
Thank you. So let's turn to public comment. Is Walter Gerstel on the platform?
I'm not seeing him.
You don't see him? All right. So let me make a few comments then about public comment at this 4 o'clock session. This is one of the sessions in which interpretation is being provided between English and Spanish and English. We will have 1 or 2 more of those. The next one will be October 27th. Lisa, would you like to say something in Spanish in the event someone is listening?
Of course, Madam Hearing Officer. Buenas tardes. Estamos ofreciendo interpretación de inglés al español y español al inglés para los propósitos de comentario público. Si hay alguien que desea dar sus comentarios públicos en español, si nos pueden dejar saber, van a haber otras oportunidades para dar sus comentarios públicos. El siguiente va a ser el día 23 de noviembre.
Thank you very much. So just a few things. I'll ask you to spell your first and last name. I'll ask you to swear or affirm that you will tell the truth. I'll ask you to keep your oral comments to 3 minutes. You may certainly add to whatever you say orally in writing. Written public comments go to Sheila Apodaca, the Commission Administrator. Thank you all. So Sheila, who is our first person, Sherry Morrison?
Yes, that's number 1.
All right. Ms. Morrison, can you unmute yourself? Ms. Morrison? Let's see. You may need to press Control-Shift-M to unmute. Sheila, I see someone named Paul Morrison has his hand up. Would you unmute Paul Morrison instead, please? Mr. Morrison, can you unmute yourself? You may need to hit Control-Shift-M. Okay. Can you unmute yourself now, Mr. Morrison? No. All right. Sheila, I'm not sure what's happening with the Morrisons, but I see that Senator Townsend is on the platform. Would you allow him to unmute himself, please?
Okay, he's been given permission.
Senator, can you unmute yourself? You may need to hit Control-Shift-M.
Can you hear me now?
Yes, yes. Thank you very much.
Okay,
Thank
thank
you.
you very much.
Senator, I see that your name is JIMTOWNSEND. That's for the transcript. Do you swear or affirm to tell the truth?
I do.
Thank you.
So-
Go
so
ahead.
help me God. You bet. Thank you for the opportunity. My comments today are in opposition to the increase that is being proposed. Today, operators in New Mexico pay a substantial fee into the reclamation fund. That fund has been used and diverted for many other purposes over the years, and it has been drawn down and not used as it was originally agreed upon. One. Two, this issue has been debated by the legislature on more than one occasion. The last time I think was in about 2018 or 19. And there was a decision made then to increase it, and that increase at that particular time was substantial. And I believe it is sufficient. And when you take that increase of just a few years ago and the proper use of the reclamation fund, that effort would be more than funded. And the third thing I'd like to say is that when issues like this are debated and a conclusion is reached in the legislature, I don't believe it is proper for this to be taken in another, kind of around the back door and try to do something that when they don't get the right answer or when they don't get an answer that they agree on, whether a secretary wants to go have a rulemaking over here or rulemaking over there, or somebody wants to take it around and go through the courts, that's not what this process is about. And so I strongly oppose this. I think we have the tools within our tool chest to use to address the issue. And if we would straighten out the misuse of the reclamation fund first and we would give that time to recuperate, we would have more than enough to do to meet the needs of any wells that might need to be plugged. So those are my comments, and that's the reason I strongly oppose.
Thank you very much, Senator.
Thank you.
Sheila, would you go back? Oh, all right. Rod Montoya, can you unmute yourself?
I think, can you hear me?
Yes, I can. And for the transcript, your name is spelled RODMONTOYA. Do you swear or affirm to tell the truth?
Yes, I do swear and affirm to tell the truth.
Thank you. Please go ahead.
Okay, and then by the way, I'm House Representative Rod Montoya. I'm the ranking member on House Energy Committee for the Republicans.
Oh, thank you.
So I wanted to follow up a little bit on what Senator Townsend just said. And further than just the fact that the dollars that are going into the reclamation fund are being diverted, they have been diverted for years and years. So this year, Representative Mark Murphy, myself, Democrat Representative Meredith Dixon, and a couple of others, we introduced House Bill 403, and it made it through the Energy Committee unanimously. And there are 6 Democrats on that committee and 4 Republicans. And I'm sorry, 7 Democrats and 4 Republicans. And it was unanimous. And what that House Bill 403 did is it started to divert money back to the reclamation fund, which it's supposed to be for financial assurance. And the amount of money that's being diverted, or at least the amount of money that was diverted last year out of the fund to the general fund, was $129 million. If those dollars would have remained in the fund, we would have more than enough money to plug the approximately 2,000 wells that are out there. As a matter of fact, if we just diverted the money back to the fund the way it's supposed to be, instead of going to the general fund, which is not the purpose, it would take about 4 years for all of the wells that are currently need to be plugged, could be plugged. So this rulemaking is unnecessary, in part because we were working towards a solution in House Energy Committee, and we had the agreement of every member of that committee to move forward. So quite frankly, you're preempting the actual process that we have, because there's more than enough money coming into the general fund that we could completely backfill the money if it were to go to where it's supposed to go. So I would suggest that even if you're wanting to do this, you shouldn't do it before the 30-day session, because we are planning on addressing this. And if you want to look it up, House Bill 403, and it's something we're trying to negotiate right now. So please let the legislature do our job. And as Senator Townsend said, don't usurp our authority. Thank you.
Thank you, Representative Montoya. Should we go back to the Morrisons, Sheila? If they're still on.
Okay, my name is Paul Morrison.
Oh, hello. I
And
can.
what's that?
I can hear you. Thank you.
Oh,
So for the
okay.
transcript, I see your name is spelled PAULMORRISON. Do you swear or affirm to tell the truth?
Well, I missed that last sentence.
Sorry, do you swear or affirm to tell the truth?
Oh, yes, I do.
Thank you. Go
I
ahead.
swear. I
Go
swear
ahead.
to tell the truth.
Please go ahead.
I just tell the truth naturally. But okay, my name is Paul Morrison, and I want to thank you for the opportunity to make some comments here. I have lived in New Mexico for 23 years. And during that time, our son earned his PhD at UNM, and he is now chief economist for the Department of Transportation. His department is very concerned with the oil and gas industry. As you may know that the Department of Transportation is pretty well self-funded, and his job is to help find out how much money is going to be coming in. But so it's important to him so they can get funding there. And my work before I came down here as a retiree was put me in touch with the oil and gas industry through my underwriting career. My econ degree is helpful for that, and I can analyze risk and price for it. But this is something completely different. But I know from my work that there's so many different skills and crafts involved in production of oil and gas and all the ancillary things to it, and further down the line. That includes, and that does make it so that there's an awful lot of employees depending on oil and gas, and more regulations don't help. So I would like to say I'm opposed to any more regulations, and maybe we could get rid of a few of them that are not really useful. I also worked with the oil and gas industry in Alaska, where the jobs are very similar but slightly different, and it's all very inclusive, and there's a lot of federal regulations as well. And the oil and gas production in New Mexico provides an awful lot of energy for our country, and we cannot make it on the renewables. The solar and wind do not help the base power, and they're not going to help anything as much. They help a little, but we still need power plants running on natural gas, as they're doing a great job now in different parts of the country. And so we need to promote oil and gas industry here in New Mexico rather than trying to limit it, which I think more regulations would do. And so I thank you, and I think other people ought to get involved to help. And that's the end of my comments. Thank you.
This is Sherry. Can I just speak right now?
Yes, you may. Is your first name spelled Sherry?
Yes.
All right, Sherry Morrison. Do you swear or affirm to tell the truth?
Yes.
I'll start your time.
I swear.
Thank you.
I swear to tell the truth.
I swear to tell the truth.
Go ahead.
Okay. Like I said, my name is Sherry Morrison, and thank you for giving me the opportunity to present my concerns. I've lived in New Mexico for the last 23 years. My family immigrated to the U.S. when I was 3 years old. My father was so thankful to America because he fulfilled his dream by building two successful small businesses. Transportation was critical to both business. One business was where he made box springs, and he had to transport the box springs all over the West. The second one was making and distributing Mexican food. They would go to Hatch to get the chilies, and again, transportation was critical to move the products to make the spices, the salsas, the beans, etc., to be sold and then to distribute the final products around the area. When energy prices increased, I saw that what resulted were higher costs for consumers and also sometimes loss of jobs for the employees. I know small businesses are the backbone of New Mexico, and many of the small communities only have small businesses, and transportation is critical. If more regulations cause gas prices to go up, then many small businesses will be forced to close due to the high regulation and higher prices. New Mexico residents will be the last to be affected, which will lower their quality of life. In addition, they will end up being the losers. So I urge you to consider the impact these increased regulations will have on New Mexico and its residents. And I thank you very much.
Thank you very much, Ms. Morrison. RH Rebecca Hollenbeek. Can you unmute yourself? You may need to press Control-Shift-M. Rebecca Hollenbeek. No, all right. Shall we try SM first? Let's see, where did SM go? Oh, I think SM was Sherry Morrison. Sorry. Ms. Hollenbeek, are you able to unmute yourself? Apparently not.
And Walter Gressel, I believe, is on the line.
Oh, is that Mr. Gerstle? Hello. Can you unmute yourself, Mr. Gerstle? You might have to press Control-Shift-M. We're not hearing you.
I've tried something else. Let's see if he can do it now.
You can unmute yourself. Perhaps Control-Shift-M or pressing the unmute button.
Now do you hear me?
Yes, thank you. Is your name
Okay.
for the transcript WALTERGERSTLE?
Yes,
And do you swear or affirm to tell the truth?
I swear that I will tell the truth.
Thank you. Yeah, please begin.
Hi, hello, New Mexico Oil Conservation Commissioners. My name is Walter Gerstle. I am a professor emeritus of civil engineering at the University of New Mexico. These are my personal comments regarding the necessity to adequately clean up the environmental destruction created when extracting oil and gas from deep underground. It is clear that until now and currently, the requirements for cleanup from gas and oil extraction are inadequate. When we talk about sustainability and circular economy, we cannot afford to allow gas wells to be left unplugged and orphaned after they become uneconomical to operate. On a more general note, the burning of fossil fuels is unacceptably damaging our environment. Drought, excessive heat, wildfires, and flooding have been clearly exacerbated by climate change caused by the burning of fossil fuels since the advent of the Industrial Revolution. The public pays dearly for these effects of climate change. We've seen a lot of forest fires and flooding in New Mexico, and as well as drought, which are linked to climate change. New Mexico is in the difficult position of relying in the short term upon revenues from oil and gas extraction, while at the same time seeking to limit carbon emissions in an effort to save the environment. These goals are in conflict. One small step that we can take is to at least make sure that the companies that profit from oil and gas extraction clean up their operations once their wells stop producing. The proposed rules must ensure that all oil and gas wells are plugged at no cost to the state of New Mexico. People's health has been shown to be negatively affected by proximity to oil and gas wells. Please set the strongest possible rules for plugging of oil and gas wells. We should strive to leave the state of New Mexico better than we found it. Thank you.
Thank you, Mr. Gerstle. Is Rebecca Hollenbeek able to unmute herself at this point?
Yes, ma'am.
Oh, terrific. I can hear you. Is your name spelled REBECCAHAULENBEEK?
Yes, ma'am.
And do you swear or affirm to tell the truth?
I do.
Please go ahead.
Hi, my name is Rebecca Hollenbeek, and I have lived in New Mexico for 50 years. I was raised in Alaska, so the energy industry has played a prominent role in my life. My father, brother, and I have had the unique experience of working in construction. Having worked in construction, I have seen the impact oil and gas has made on the economy of the entire state. Every person and business requires goods to be transported to their location. I support the industry because both of my children went to our public school system, and therefore I'm very concerned about funding being pulled from our schools. Currently, we are 50th in the nation in education, and I would like to continue to see funding for our next generation. I can see no other industry being able to step in with the additional support that the oil and gas industry has provided to us. I would appreciate the commission rejecting this regulation, since it would not only put small business oil and gas companies out of business because they would not be able to afford the new regulations. And when they go out of business, then it affects other companies to be going out of business as well. Examples being construction companies, restaurant, housing projects, banks, and mom and pop shops. Having lived and worked on and near military installations, I can also see how the oil and gas industry affects our national security as well as our standing in the world economy. Thank you very much.
Thank you, Ms. Hollenbeek. Sheila, do we have anyone else on the platform desiring to make public comment at this time? There'll be another opportunity tomorrow at 9 in the morning, another opportunity tomorrow at 4 in the afternoon.
I don't see any other hands raised.
Well, Ms. Hollenbeek's hand is raised, but no others?
I don't see any others.
All right, and no one has joined us in the room. All right, so here's the thing. We've been going a little more than 90 minutes, about 100 minutes, and we need a brief stand-up break. So let's come back at 4:30 and we'll return to Mr. Morgan. Thank you.
And Madam Hearing Officer, may the interpreter be excused?
Thank you, Lisa. Yes, thank you.
Thank you. Have a good afternoon, everyone.
Let's come back from the break, please. I know that was a really short break, but we can only go about another 30 minutes. So wanted to keep us cooking along, as Mr. Tremaine said. Let's see, I see Mr. Morgan on the stand, Ms. O'Grady.
I apologize. My computer is shut down unexpectedly and is restarting. Please give me just a moment, but I do believe we only have about 10 to 15 more minutes of his testimony, so it should fit perfectly with the rest of this afternoon. Thank you. Sheila, Tanis Fox would like to share her screen, please.
Okay, she has permission.
Really appreciate everyone's patience there. I think that we have the slide deck up. Perfect. And I am going to restate the question that we were on when we received an objection. So, Mr. Morgan, IPA&M and NMOGA witnesses object to the proposed amendment that prevents drilling or acquisition until the operator has furnished the required financial assurance, claiming that the proposed new language is vague and broad and would inject a new pre-acquisition approval power. What is your response?
So as we just discussed, the hearing officer addressed a similar argument in her recent recommendation on the motion to dismiss, noting that the movements suggest insertion of the phrase operating authority to remove any confusion over the effect of this provision. Applicants support insertion of the phrase operating authority or related phrases at 3 points in section 1915-89A NMAC, both in the proposed additional language and in the existing portions of the provision. This newly proposed language is reflected in applicant's Exhibit 88, which has been handed out to the commissioners and all parties. I'll note it is not reflected on the slide here, but I'm going to describe where it fits within there. So in all cases, the phrase operating authority follows and modifies the phrase drilled or acquired or similar phrase. So this occurs twice in the existing language and then in the language that's highlighted in red in the slide, and again is reflected in Exhibit 88. This approach of modifying drilled or acquired with the phrase operating authority is entirely consistent with applicants' original intent, which has always been to require financial assurances prior to a change in operating authority, which already falls under OCD's authority. Nothing in the proposed language suggests that OCD would or could have a role in approving the sale of a well. Operators engaged in the sale of wells should, however, continue to be aware that even after a well is sold, if the parties wish to change the designated operator, that step does involve OCD oversight and review. It is inherent in any financial assurance scheme that the financial assurance must be provided before the obligation is incurred, whether it be drilling the well or becoming the operator of an existing well. It would defeat the entire purpose of financial assurance were it otherwise. For example, what would happen if a well were drilled and then the operator could not secure a bond or other financial assurance? OCD would be without recourse because it would be too late to undo the activity giving rise to the obligation. You cannot undrill a well. If the operator were not then able to provide the required financial assurance, OCD would still be responsible for covering the full plugging cost in the event of orphaning.
NMOGA, IPA&M, and Oxy witnesses object to the proposed new categories of financial assurance for marginal wells, claiming that the one well financial assurance of $150,000 for marginal wells, inactive wells, and wells in approved or expired temporarily abandoned status would be prohibitively expensive for operators and may disproportionately affect smaller operators. What is your response?
Because it is OCD that is responsible for plugging wells that have been orphaned and subject to financial assurance forfeiture, the only relevant figure for determining the typical cost to plug and abandon a New Mexico well is the cost to OCD. The current average cost to plug a well in New Mexico is $163,000, though OCD has reported average costs as high as $180,000 per well. To the extent witnesses for NMOGA or IPA&M claim that the $163,000 is artificially high and attributable to factors that OCD is in the process of correcting, that potential is already factored into the proposed amendments. The proposed amendments set one well financial assurance amounts at $150,000, not $163,000. Nothing in the proposed amendments targets small operators. Small, medium, and large operators are all subject to the financial assurance requirements. That said, smaller operators should be required to comply with the same regulatory requirements as any other operator and should not be exempted. These requirements, including financial assurance requirements, are intended to protect New Mexico's communities, environment, and economy. If an operator cannot comply with these requirements, it should not be in the oil and gas business. It's also worth emphasizing that wells that enter into marginal well status can also come out of marginal well status if production sufficiently increases. Such wells would no longer be subject to the increased financial assurance amount. The proposed amendment at 191589D2 NMAC which is reflected in applicant's Exhibit 72, provides that, quote, each operator with a marginal well or wells shall annually review the number of marginal wells registered to the operator and shall update the one well plugging financial assurance by May 1 of each year. Any marginal well that was plugged or where production increased above the threshold would no longer be included in the operator's marginal well count following that annual review. This was language applicants and OCD negotiated with OCC.
NMOCA witnesses object to the inflationary adjustment provision in the proposed rules, claiming that it would lead to a conflict with the statutory cap for blanket financial assurance. What is your response?
The opposition to this proposed amendment overlooks that the proposal expressly provides OCD with discretion to decline to adjust financial assurance amounts in any given year. The proposal says only that, quote, the division may adjust the financial assurance amounts. This inherent discretion is adequate to address concerns related to actual costs experienced within the oil fields and other practical considerations. The $250,000 cap on the amount of blanket financial assurance is not relevant to the proposed amendment allowing for adjustments to financial assurance amounts because the proposed language expressly excludes blanket financial assurances for active wells. The blanket financial assurance amount for active wells is set at 1915-89C2 NMAC. This subsection is excluded from the list of financial assurance categories subject to the adjustments. That provision applies only to the financial assurance amounts provided by subsections C1, D, E, and F of this section.
After negotiations with OCC, applicants proposed to amend 1915-98 operator registration and 1915-99 NMAC change of operator, correct?
Yes, the amended proposal makes three fundamental changes that appear and recur in the proposed amendments to sections 1915-98 and 1915-99 NMAC. First, the amended proposal replaces, quote, officer, director, or partner with authorized official. This provides operators with greater flexibility in determining who is most suited to provide the required certification and accommodates a broader range of company structures and position titles. The amended proposal also eliminates the phrase is in compliance with federal and state oil and gas laws and regulations, and replaces it with a list of more specific and concrete actions and statuses. The focus on forfeiture demands and actual forfeited financial assurance provides a very specific and easily trackable metric. No operator can claim to be unaware of a forfeiture demand or a past forfeiture, as this is a serious consequence that would be obvious and well known within a company. Forfeiture also occurs at the end of an administrative process where an operator has multiple opportunities to correct an innocent mistake or paperwork violation. Similarly, the reference to unresolved adjudicated orders or unresolved settlement agreements captures instances where operators have been unable or unwilling to comply with program requirements, even after being duly notified and given an opportunity to correct. Such are the operators and scenarios most likely to warrant increased attention and action by OCD. To the extent the proposed amendments reference oil and gas statutes and regulations in other jurisdictions, this is merely to provide information to inform purely New Mexico-focused actions by OCD regarding operators seeking to do business in New Mexico. Nothing in the proposed amendments authorizes or requires OCD to take any action outside of its jurisdiction.
IPA&M and NMOGA witnesses claim that the proposed compliance provisions could lead to unfair treatment of operators based on a former employer's non-compliance, and that the proposed provisions would delay development and acquisitions. What is your response?
The parties opposing these proposed amendments fail to explain why it is in the interest of New Mexico or the industry itself to facilitate the continued employment of bad actors. The proposed amendments bear only on executives or investors who have participated in companies that have accrued violations. If the industry is responsible and self-policing as claimed, and if documented violations are attributable to a small number of bad actor operators, the proposed amendments should not materially impact the vast majority of operators. Industry participants should already be tracking this information and should already be vetting the background of executives.
NMOGA witnesses claim that the proposed additional certifications effectively act as a prohibition on some transfers and, in so doing, violate New Mexico's ban on the impairment of obligations of contracts. What is your response?
OCD clearly already has authority to block the transfer of oil and gas assets. Under current regulations, OCD may deny a change of operator if the new operator is out of compliance with 1915-59A NMAC or is acquiring facilities that are subject to an existing compliance order and the new operator has not entered into an agreed compliance order. The proposed amendments provide additional grounds for OCD denial, but do not impose a new authority where one did not previously exist. Furthermore, and as addressed in the newly proposed language recently discussed, nothing in the regulations applies to the actual sale of a well, only to the change of operator for regulatory purposes.
IPA&M and NMOGA witnesses claim that the terms substantial risk and good standing in the disclosure requirements are vague and subjective. What is your response?
Existing provisions already authorize OCD to deny operator registration or change of operator. These are already inherently discretionary provisions, and nothing in the proposed amendments changes that. The crux of any discretionary determination as to whether to approve or deny a change of operator would be assessment of whether the applicant poses a, quote, substantial risk that the new operator would be unable to satisfy the plugging and abandonment requirements, close quote. Furthermore, the substantial risk determination is not open-ended, but is grounded in OCD's assessment of the information operators are required to provide and whether that specific information reveals that the new operator will be unable to satisfy the plugging and abandonment requirements. Good standing is a well-defined term of art under New Mexico law. The Secretary of State's office is specifically empowered under New Mexico statute to issue a certificate of good standing for a corporation, limited liability company, or other entity. The inclusion of the reference to in good standing with the New Mexico Secretary of State is a recognition that a corporation or other entity may have registered with the Secretary of State's office but then fallen out of good standing, for example, by failing to pay certain fees or file certain required reports. The proposed amendment merely closes that loophole by requiring that an operator be both registered and in good standing.
Thank you for the summary of your rebuttal testimony. Madam Hearing Officer, we anticipate roughly 15 minutes of Sir rebuttal. Would you like to hear that today?
I think that's a good idea. We have 11 minutes to 5. Is it okay if we go 4 minutes over? All right, please go ahead.
Okay, thank you. Mr. Morgan, NMOGA witness Douglas Emmerich claims on pages 10 through 12 of his rebuttal testimony that the W&T offshore litigation shows that changes to regulations will automatically lead sureties to increase collateral demands on operators, including as a means to get free of non-cancelable surety contracts. What is your response?
Like Mr. Emmerich, I have also been closely following the W&T offshore litigation. I disagree with Mr. Emmerich's characterization of the facts and significance of that litigation. Mr. Emmerich repeatedly frames the lawsuit as arising out of surety providers' demand for increased collateral as a direct response to changes to the Department of Interior's financial assurance regulations for offshore facilities. The actual statements of the surety providers in the litigation show that they were not specifically responding to that rule change, but were instead motivated by the financial condition of the W&T entities, together with other existing economic trends within the industry. Here's how the sureties describe the reasoning behind their demands for additional collateral. Quote, "Since Lexon issued the surety bonds at the center of this litigation, W&T has reported significant deterioration of its financial health. That development, coupled with numerous other industry-wide issues, including relevant court rulings, losses sustained across the industry, and reinsurance considerations, led Lexon to send a collateral demand notice to W&T. W&T's other sureties, who each have their own indemnity agreements with W&T, apparently observed the same financial trends and independently decided to demand collateral payment from W&T." This is from Lexon's partial motion to dismiss, which is document 57 in the litigation. There is no reference in that statement to the DOI rule, despite the surety's listing of multiple factors to which they were reacting. This articulation of the surety bonding industry's general concerns with the health of the oil and gas industry and the risk of operator default is consistent with Mr. Emmerich's own statements. In his direct testimony, Mr. Emmerich observed that, quote, "The simple fact is that the surety market today is very demanding and difficult to navigate. Surety companies have become more restrictive in their underwriting guidelines to minimize the risk that a bond will be called," close quote. In that same W&T litigation filing, the sureties also articulate why a surety provider would not respond to a financial assurance rule change by dramatically increasing demands on operators under existing surety bond contracts, noting, quote, "It would make no sense and be economically irrational for the sureties to take any action that would threaten W&T's financial viability such that it could not perform its obligations because the sureties would then be on the hook for those obligations. W&T does not explain why the sureties would be motivated to force potential customers out of the market. It would be economically irrational for the sureties to require impossible collateral payments, cripple their customers, and demand collateral terms that would effectively prevent smaller oil and gas companies from obtaining government-mandated bonding. The same logic would apply to sureties' expected response to a rule change in New Mexico. Far from establishing that a change to financial assurance regulations will prompt a negative response from surety providers, the W&T litigation confirms that surety providers already have significant concerns about oil and gas operators defaulting on their plugging obligations. The Commission should share in those concerns and take common sense actions to protect the state by amending New Mexico's regulations as proposed by the applicants. Mr. Emmerich's repeated emphasis on the non-cancelable nature of financial assurance requirements in New Mexico is also telling because it completely ignores the needs and priorities of the beneficiary of the financial assurance, the state. Mr. Emmerich emphasizes that for surety bond providers, quote, "The ability to cancel or non-renew is a critical risk management tool," close quote. That may be true, but what this statement omits is that as the surety's risk goes down, the state's risk goes up. Were the state to allow operators to provide cancelable surety bonds, there would be no financial assurance to call on by the end of a well's productive life. Under that scenario, sureties would have every incentive to provide bonding during the first few years of a well's initial profitable production. That's basically free money for the surety, where they can pocket the annual premium payments while bearing essentially zero risk of having to pay out the cleanup bond. But as soon as the well's production goes down, the surety's calculus changes. As production declines, the risk of having to pay out the bond goes up. At that point, a rational surety would cancel the bond or decline to renew a term-limited bond. Once the initial surety cancels its bond, no rational surety would be willing to provide a replacement bond. As Mr. Emmerich stated in his direct testimony, quote, "For a host of reasons, surety companies have become more restrictive in their underwriting guidelines to minimize the risk that a bond will be called," close quote. Once the initial bond is canceled, the state will be left with no recourse and no protection. It should be noted, however, that a surety contract is a three-party contract, and OCD, as one of the parties, may release a bond. For example, if a well increases production and no longer qualifies as a marginal well, OCD could release the extra marginal well bonding.
With regard to new single well financial assurance provisions for marginal wells, IPA&M witness Trevor Gilstrap claims on pages 5 through 6 of his rebuttal testimony that applicants have not offered evidence that marginal well operators are more likely to be out of compliance or more likely to abandon wells. What is your response?
Applicant's proposal to require one well financial assurance for marginal wells is motivated by the heightened risk that these low-producing wells will be orphaned to the state. That risk is the product of simple economics. Marginal wells produce little revenue, particularly as compared to plugging costs, and much of that revenue is already committed to other purposes, including royalty payments and well maintenance unrelated to plugging. So even if all remaining revenue from these wells were set aside only to pay for plugging, the funds would be inadequate for the purpose. Now, some operators may be able to use revenue from higher producing wells to cover the costs of plugging marginal wells. But the question remains as to how, excuse me, the question remains as to where the funds will come from to plug the last of those operators' wells. No industry witness has provided any testimony that operators of marginal wells are in the practice of setting aside such plugging funds during periods of higher production. To the contrary, both Mr. Emmerich and Mr. Gilstrap state in their testimony that marginal well operators maintain very low levels of working capital such that they could not satisfy a surety provider's requirement that they have the equivalent of $37,500 in available working capital per well. Plugging wells costs money. If marginal wells will not cover their own plugging costs, and if operators have not otherwise set aside the funds, then the only reasonable conclusion is that these wells will not be plugged by their operators. That plain reality gives rise to the need for the state to protect itself by requiring single well financial assurances adequate to cover the costs of plugging. Finally, the proposal to require one well financial assurances for marginal wells is unrelated to marginal well operators' compliance with regulatory provisions other than the requirement that they complete well plugging. The heightened risk that motivates the need for one well financial assurance is the risk that the operator will orphan the well, not other risks related to operation or maintenance of the well.
NMOGA witness Dan Arthur objects to your use of OCD's average plugging costs on page 73 of his rebuttal testimony. Specifically, he claims that you emphasize headline averages without analyzing median costs, trimmed means, or stratification by depth or well type, and that by his analysis, removing even the top 10% of cost outliers drops the average far below the $150,000 figure that you cite. What is your